Our first panel will discuss the recent movement by both legislators and agencies to regulate digital assets and ask whether this regulation is affected by party lines. Those online, please submit questions in the chat for Q&A. This panel will be moderated by Professor Perry Merling of the Boston University Party School of Global Studies. The panelists are Jonathan Gould, partner at Jones Day, and Timothy Duncan, principal and founder of Cambridge Financial Technology and lecturer at Boston University School of Law. Tonantzin Carmona will not be able to attend today. Thank you.
So I guess that's my cue. So I'm Perry Merling, and initial disclaimer for this audience is that I am not a lawyer. I'm an economist. And so I enter this question from the point of view that every move to financial regulation is appealing to some economic theory of money or finance or something, usually implicitly. And my job is to make that a little explicit. And so a little advertisement. Just last November, I published with two co-authors a working paper at the BIS on par, a money view of stablecoin, which is intended to give that kind of intellectual analytical guidance to people whose job is regulating this new development. And I was stimulated to, this is the first thing I've ever written for publication on crypto, and it was stablecoin that stimulated me. Okay, when Bitcoin was invented, when I was teaching money and banking back at Columbia University, I don't know, 15 years ago or so, I took a look at it and I said, that's going nowhere from the point of view of monetary economics and payment systems. And so I stopped paying attention. Okay. Well, it did go somewhere, but it went in evolution. So I've been watching this regulatory debate, and in our instructions from Marina, we were asked, and in some ways this was a useful frame, the debate for a while has been, well, what is this crypto thing? You know, is it a security? In which case we should ask the SEC to do something about it. You know, is it a commodity? In which case we should ask the CFTC to do something about it. And that's sort of where the debate was for a long time. And there was some pushing and shoving, and crypto advocates were spending a lot of money, and those who were opposed to it, mostly traditional banks, okay, who felt threatened a little bit, were spending a lot of money, and they were throwing money at lawyers, and they were throwing money at congresspeople in order to influence all of this. So I come to you today to say that I think that the creation of stablecoin, okay, has changed all that dynamic. Okay, that's still playing out. The SEC is still doing stuff. CFTC is still doing stuff. But the 900-pound gorilla in the room is the Fed. Okay, and the consortium of central banks, the Financial Stability Board and so forth, because once you have stablecoin, you are messing with the payment system and you are messing with issues of financial stability. And that got the attention of central banks big time, okay? And they are focusing right now on that. And they have very strong views. They will have very strong views about the kind of regulation, and they will be telling Congress what those views are. You might not see it, okay, but this is happening behind the scenes. The stablecoin, I'm going to say one thing about stablecoin, and then I'll turn to the panels. It's shifted this debate. A lot of this came about because of this period of zero interest rates during COVID and even before, that there was a search for yield, and crypto world seemed to offer, you know, speculative opportunities. And the way to get into crypto world was stablecoin, and you could lend your stablecoins for 10%. You know, even when there was 0%, you know, in the fiat world. And so we got a bunch of flavors of these stablecoins. We got Terra, we got Tether, we got USDC, and then when Powell started raising interest rates after COVID, that was a stress test for all of these, and we saw them collapse. You saw the problems with Terra went away. We saw problems with Tether. Turned out that Silicon Valley Bank was in fact holding the reserves for USDC, so the collapse of SVB was really a test of that. And meanwhile, competitors to stablecoin have been growing up inside the regulatory So we have JPM coin, we have central bank digital currencies, we have so-called tokenized deposits. So the debate is very different, I think, today than it was before stablecoins, and possibly the public awareness of that debate has steeled back, thinking this is really about whether we should give this authority to the SEC or the CFTC. So that's my kickoff, and I will now, what I propose to do, we'll hear from our two panelists, and then maybe have a little discussion among ourselves. I think there's some controversy here, and I'll let them tease it out, and then we'll have some Q&A.
Thank you. So I'm Jonathan Gould, very happy to be here. So the way I kind of thought about this question was first kind of examining what do we mean by the politics of financial regulation as applied here. And so, when I think about politics and what it means in financial regulation, I thought about, who controls, who has power, the governance. That, to me, that's what kind of politics means, the politics of financial regulation, and how do we use financial regulation to answer those questions? And kind of the rise of crypto, including stablecoin, I think, has the potential to pose some really interesting questions, at least theoretically, in the sense that crypto promised something that possibly was new under the sun, something we hadn't seen for a while, including the use of, or including not having to rely on central financial intermediaries. Now, as it's evolved, that's perhaps changed a little bit, but at least, in theory, kind of in its Platonic ideal, it involved, a system in which there were no financial intermediaries, right? Which really posed challenges, I think, for kind of the existing political framework kind of writ large, in terms of how you kind of allocate control, governance, power with respect, through financial regulation with respect to crypto activities. So the way I kind of think about it is, when we talk about the politics of crypto, who can do it, where, how, what can they do? I think those are all questions you have to answer, or at least think about when trying to address the politics of financial regulation. So I spend all the time kind of thinking about the various players, and the players have evolved and changed and shifted in their relationship to one another as they kind of attempt to answer these questions around power, control, governance. Again, as articulated through financial regulation, that's shifted over time. But I think about the various government agencies. You referred to kind of and I agree with this, the kind of the potential for the increasing role of the Federal Reserve, particularly as it comes to stable coins. But more broadly, kind of the central bankers' interest in additional sources of private money is something that obviously is fundamentally important to them, and can potentially raise existential questions. Then there are also kind of another key player, obviously, are Congress and its committees. And there, I think one of the interesting phenomena that we've seen is, just because of the general committee structure of Congress, in particular, on the market regulatory side, the split between the Senate and the House kind of banking and agricultural committees, which others have noted in the past, and which became an issue in Dodd-Frank with this split between how to regulate the swaps world. Well, you have these two congressional committees, and that poses, just as a practical matter, certain challenges. And I think we've seen that repeated too in this case, around the fundamental question of what is the security and who should be the regulator. Then there's also the age-old, at least in the U.S., the state versus federal tensions, which play out in a lot of different formats. I think we're seeing them play out, for example, in connection with stablecoins as well. What is the appropriate kind of analog for thinking about stablecoin regulation, and to what extent and how do you allocate the responsibilities between the states versus the feds with respect to stablecoins? Do you think about it more like a bank? Do you think about it more like a money transmitter license? And I think what kind of model you use or analogy you draw from really influences how you allocate the various responsibilities and roles between the states versus the feds, with respect to kind of the regulation of crypto broadly. And then again, as you've alluded to, I think there is kind of interesting tensions too between banks versus non-banks. Again, that plays out in the stablecoin context. Who should be able to issue stablecoins? Should it be the exclusive purview of banks, or should non-banks be able to issue stablecoins as well? And under what terms, under what regulation, who regulates them? so those are kind of the players I think are involved. And I just want to echo the stablecoin point because I think that's an important one. I think for a while, and understandably, a lot of the focus was on kind of the market regulatory side and the question of, is this a security or not, which was, I think, a threshold question. That question may ultimately be answered by the courts, which I failed, but should have included as well in the players here. Courts increasingly are kind of the policymakers of last resort. Whether or not that's a good or bad thing, I think it's inevitable. And at least over the last couple of years, there's been a lot of litigation, which is where many aspects of crypto policy may in fact be made as kind of a default matter. But the kind of the importance of stablecoin, I think, does mean that although the banking agencies were kind of not the initial kind of players in this area, I think it is inevitable that they will become increasingly important as players, particularly to the extent that many banking agencies are concerned that stablecoins look a lot like other cash-like instruments, including money market mutual funds, where there have historically been issues with money market mutual funds during various kind of market stresses, including as recently as March 2020. And I think the banking agencies, generally speaking, have concerns about allowing stable coins to be the exclusively domain of, say, a market regulator. I think over time, if I were betting, I would think the banking agencies would kind of exert their influence increasingly over time with respect to stable coins. I think we're kind of seeing that through interagency bodies, including the Financial Stability Oversight Council as well, and its focus and the way it thinks about things, which I think are heavily influenced through kind of the bank lens. So let me stop there and let's do the next.
Tim?
Where to start? So the issue politically seems to me to be whether or not we create a whole new set of laws for this sort of amorphous thing we're calling crypto, or carve out special exemptions from existing laws such that existing laws don't apply to the crypto world in the same way they do to the rest of the financial world. And my answer to that is, for the most part, no. I think there could be interesting things around stable coins. It's perhaps a little bit different than that answer. And I guess the second part of my answer is whether we should change the law would be, we already have significantly in the form of, or in the process in the form of the recent amendments to the UCC and the introduction of Article 12 around consumer electronic records. I think that that's an important and rather profound development that tends to get overlooked with the rest of the back and forth around cryptocurrency and the politics around that. So I guess what I bring to the discussion is that I'm old enough. I started one of the first financially oriented companies on the internet back in the late 90s, and I was around when the politics around that were kind of exciting and interesting, where Congress in fact carved out certain exemptions. I think Section 230 of the Communications Decency Act to exempt internet companies from libel laws, exemptions from local use taxes, things like that, where the idea was that this was a significant innovation. Existing laws didn't really make sense in some regard, and that it was important that America developed these capabilities in the internet to retain its innovative edge. And it's funny because the crypto industry seems to have sort of gone back 20, 25 years and adopted kind of the same playbook. I would contest vigorously the idea that the development of crypto has anywhere near the innovative significance that the internet did. And I say that with some degree of experience because I do have a technology background. About 7 or 8 years ago, I did work on a couple projects with the big banks, there's a lot of excitement that sort of filtered up to the CEO suite, and then the CEO was talking to the COO, who was talking to the CTO. I read about this stuff, and it seems like there's something there. What is XYZ Bank doing about this? And of course, everybody went scurrying around, trying to hire people, and let's figure out something. I need to get back to the CTO, the CEO with what we're doing with crypto, with blockchain, et cetera. So my experience in that was that, and I think it's important to sort of, break crypto into sort of more component parts. And the first thing I would talk about would be the blockchain, public blockchains. And that when you look at the public blockchain in terms of a technology, it's really a big nothing burger. You sort of, it's a ledger. You're putting a big Excel spreadsheet in the sky someplace, and you're giving people from all over the world, most you don't know, the keys to make adjustments to that ledger. And the primary use case for public blockchains is to avoid scrutiny, avoid the law. And when that use case is removed, which I would hope most banks and financial service companies would have other intent than just to avoid law, it's really not a very efficient technology. As a matter of fact, it stinks. It's got latency problems, it's got privacy problems. There's all sorts of issues with it. There's no reason to use it really for any kind of financial services at scale. And what we've seen then is that, kind of, again, sort of amorphous concept that the banks are using crypto these days, or bank stable coins or whatever we have. In fact, those are private ledgers, and private databases, private distributed databases have been around for 30, 40 years. There's nothing new under the sun there. And we haven't had to adopt new laws to deal with distributed databases before, and I don't think we need them now. I do think that, and not to mention, the problem with the environment, the burning of electricity, small things like that. So at the end of the day, I don't think there's really much there in terms of crypto which would support a claim for importance of innovation in the United States, that somehow we're going to fall behind if we don't are one of the leaders in public blockchain or crypto. I just don't think that's true. I do think, though, that again, people are sort of ignoring Article 12 and our recent changes to the UCC, which I think are extremely important. I talk about this in my class. If you go back to the 17th century, you had an incredible technological innovation occur there over about 50 years prior to the statute of frauds. And that was the fact that literacy grew at an enormous rate. We went from less than 5% of the population to 50, 60, 70% of the population was literate, could read, could write, in the early 17th century, which people started figuring out, like, well, let's we can actually, instead of a handshake in front of a couple of people, we can write something down and put that in a written agreement. And instead of going to the property I'm buying and throwing sticks at it and crumbling dirt on the ground, we can actually have a contract for sale for that property. And we can actually have something called a registry, where we take the representation of that ownership and file it in this registry where other people can be made aware of our ownership interests. So it took 100 years, but this technological change resulted in the statute of frauds and the adoption of writing in contracts, property, financial services. And I think it's very similar to today. It's just an accelerated pace, where instead of written literacy, we've gone from a relatively insignificant percentage of the populace that's connected to each other via electronic network to upwards of 90+%. And the difference is in terms of, we're still sort of operating on the concept of written agreements. And anybody that went to law school with Abraham Lincoln, like I did, has a hard time sort of, getting that out of their heads that something isn't in writing. And, we started 20, 25 years ago, beginning to give credibility of electronic signatures, looking at property records that were electronic versus in writing. And I think the financial system is sort of falling behind. And the Fed kind of gets dragged kicking and screaming into where we would have been 20, 25 years ago, I think. I suppose that's good to some extent, that you want some conservatism from your central bank. On the other hand, I think it's opened up opportunities for things like stable coins and digital registries. And I think that it's the work that was done. If you're talking about changing the law for crypto and for essentially electronic records of assets, really incredible work has been done around. I wasn't involved personally, but incredible work has been done around Article 12, and I think that getting that passed is extraordinarily important. I think it's in 11 or 12 states, and the politics behind that are important. Hopefully that gets done, and I think then we're going to spend the next 10, 15 years trying to figure out exactly what that means. I was reading an article yesterday about the implications of controllable electronic records, which is the primary term in Article 12, and the impact of trading bankruptcy claims. And it was really amazing. I mean, I never sort of thought it connected the two things, but it's going to change bankruptcy. It's going to change how bankruptcy courts operate. Again, primarily because it's recognizing that records are electronic now and not in writing, and that can create all sorts of efficiencies in trading bankruptcy claims, just for one example. So that's, I think, just about all I have to say. That's it.
Thank you. So let me pose a question or two for the panel, I guess, us. What you say, Tim, as you were speaking, made me think about the question, sort of, why is there crypto? What is it? Where is it coming from? What is the pressure? Which Jonathan, you sort of took for granted that there's crypto, and now we have to address it. But the politics, okay, of this comes from interests, and your suggestion, Timothy, is that maybe one of the origins is technology, is the internet, is digital literacy, is essentially you're suggesting that something like this was going to be happening, and this is just the way it's coming about. It may be that when we are all digitally literate and not Abraham Lincoln's, the crypto as we know it today will look very different, okay, that it will not look like this. This is just the way that it got into there. On the other hand, I remember in the early days of crypto, there were lots of talk about that. In fact, there were political reasons for crypto, that it was an attempt to get away from the power of the state, get away from the evil large banks, and that initial sort of crypto punk kind of quality. What's happened to that? Now we have large centralized exchanges in crypto world. So maybe you could, I'll not ask you first, Tim, because you raised this, but ask Jonathan. So where in your musings, the politics of crypto are also about who's in favor and who's against, and why. And I am puzzled about that.
So I think, as you've noted, I think the initial impetus for crypto in 2008 was a skepticism of central authorities and a reaction to some of what we saw in the 2008 financial crisis, and a desire to take control from centralized intermediaries and devolve it to individuals. And so, that has implications from a kind of Democratic, Republican political party spectrum analysis, like how you see the issue. That's, as you've noted, that has, that rationale has at least has shifted to some extent, or at least depending upon the players involved with crypto now, there are differences, I think, of opinion of that, and there are clearly kind of central intermediaries who are serving as a kind of access points, both retail and institutional access points to crypto. But then there is also a whole world of decentralized finance which has sprung up, and who knows what will happen there. But that is, I think, more consistent with the kind of original rationale as articulated back in 2008 for a cryptocurrency. How kind of crypto aligns with the various existing political parties in the US, I think really depends upon the narrative that's told about it. If it's about individual freedom, it might mean one thing. If it's about national security, it might mean another. If it's about anti-money laundering and illicit finance facilitation, then it's yet another. I think the initial rise of crypto somewhat scrambled ideological lines. It was a little bit unclear, I think, initially, kind of how the kind of existing political parties would view crypto. Was it this great new innovation, and so you should back it? Was it just meant to facilitate illicit finance, and therefore you should try to eliminate it? Is it part of kind of this larger kind of populist gestalt that's potentially sweeping not just the U.S. jurisdiction, but other jurisdictions around the world? What exactly is it? How does it play into U.S. the status of the U.S. dollar as the global reserve currency? I think all those are different angles, and how you think about that and how you think about crypto, suggests where you might be on the spectrum. Do you support it? Do you oppose it? And so forth. I think as certainly the events of last year caused, I think, across the political spectrum, a desire to kind of put some distance between some of the politicians who had taken stances, particularly supportive stances for crypto, and how that evolves in the future, I think is unclear. I mean, it may be that, as with so many other issues, at some point in the future, kind of lines become hardened, right? So, Republicans have one view, Democrats have the other, and partly those views are just a reaction to the others, versus necessarily kind of a nuanced analysis of the particular issues. Which is to say, if one side supports it, then the other side has to oppose it, just as a matter of principle. So those could, those lines could harden. I think the crypto industry, to the extent it can be described as some kind of monolith, has attempted to resist hardening of kind of political party lines, with some success. I think there's a little bit of a bias to be more skeptical on the Democratic than the Republican side, but that's unclear to me whether or not that kind of whether that kind of split will further harden or not. So I don't know if that's responsive to your question.
Well, those are a lot in there. Tim?
So a couple things. I worked with Elizabeth Warren on Dodd-Frank. I was head of technology at the CFPB for a while. So I had a couple years experience of financial services regulation in DC and what that's about. And we didn't have much money at the beginning, at least. And then the Durbin Amendment came along, and then all of a sudden there was a lot of money. Folks like Target and Walmart were very interested in the passage. And the lesson learned there is that if you come to Washington with a suitcase full of money, there are lots and lots of people there to help you spend it, and it won't stop. They're happy to continue to spend it as long as you bring it. I'm not cynical enough yet to believe that that's all there is to it. I do think that substance makes a difference, and I don't think that there's much substance in crypto's arguments. But they do have plenty of suitcases full of cash that they're using to pay lobbyists, make political contributions. So I think that's the primary driver behind the politics of crypto. The second thing I'll just throw in there is, having been involved since the mid-90s and stuff, this idea of disintermediation is just this constant theme of often sort of hustlers, I think. I never quite got it. It's sort of this idea that we kind of like want to use the internet to go back to, John bakes a loaf of bread and I can go over to his house with 2 chickens and we can sort of do this swap in secret and everything will be wonderful and kind of like quasi barter economy on the internet. And I kind of left that behind. We left that behind, like, a few thousand years ago. And the idea that you're going to get back to this, substitute the internet for being to the same location when you're doing some sort of exchange just doesn't work. And so consequently, you still have this problem where somebody's giving somebody something and somebody else has to pay for it or swap something for it. So you've got a timing problem there, which means you've got a credit problem there. So the economy is about credit, finance is about credit. And to have credit, you need laws, and you need a legal system to enforce it. And so, it just doesn't really work, this wonderful idea of disintermediation. I mean, you end up with new intermediaries, really, in terms of Spotify is, instead of a record store, and Amazon instead of a local retailer. They're just new intermediaries. And, while crypto is making the same claims about disintermediation and not having to rely on intermediaries, we have a pretty trustworthy intermediary system in financial services. Not all the time, but for the most part, it works pretty well. And in fact, what crypto has done is just where it needed to adopt new intermediaries. So, unless you have $100 million to go out and buy a bunch of ASIC chips to set up a node on the blockchain network, you're going through Coinbase and you're going to pay, 1.5, 2.5 points to buy crypto. So I don't know how that's any different than putting it on your credit card and paying the fees there. So the new kind of ends up being the same as the old. And I think now the cryptos let traditional finance get its nose under the tent with Bitcoin ETFs. What you're going to find is that whatever is there in terms of Bitcoin value, and it will essentially be taken over by traditional finance companies and the same old intermediaries who, if you look at it, they don't really need blockchain. Blockchain is just a ledger, and there's things like DTCC to handle that. There's still blockchain does nothing in terms of market making, function, and trading and sales. You still need that, and that's what these companies provide. In the long run, I don't think they really need to use blockchain. It's inefficient, it's bad publicity, and everything else. So it's going to be interesting what happens in terms of the evolution of Bitcoin in particular.
Yeah, I mean, someone described the phenomenon you're noting as just the maturation of the industry, but it is certainly, I think it is certainly the case that there's some splintering among kind of the original crypto proponents about whether this remains true to the 2008 desire and rationale, and that's certainly going on. And to what extent is crypto also a political movement, right? Again, there's a spectrum. There's some people who would say yes, it's a political movement too, for some of the reasons I initially articulated and what it says about personal freedom or what it aspires to say about personal freedom. Others would just say this is a speculative asset class. That's why we want exposure to it, because it's volatile, but it's been going up over time. Again, I think it's important that we don't kind of think of it as a monolith, right? It's got a lot of different component parts and definitely different views, and I think increasingly over time there is splintering of those views kind of within even the crypto kind of ecosystem as to what it's for and what it should be used for.
Thank you. I want to open to Q&A. Let me just summarize what I thought I heard there, which is the original crypto really, because as Jonathan was saying, was a response to 2008 and the bailing out of the big banks perceived and so forth. And so there was an idea that credit is a bug, not a feature, and we want to get rid of it and go back to trading fish for bread. And as we experimented with that, we discovered that no, actually, in real payment systems, credit is a feature, not a bug. And that means regulation. That means you need to have trusted counterparties. You need to have enforcement of contracts. And so that's where we are right now. That's the phase in this evolution. Let us now open up, but I'm not sure how that. Are you running that? Okay.
So we had one question come in through the Q&A chat from the virtual attendees. Could the panelists address the benefits and challenges of legal use cases of private sector stable coins relative to currency, bank deposits, and CBSC when if they become viable, widely available?
I missed just the first.
Could the panelists address the benefits and challenges of legal use cases of private sector stablecoins relative to currency, bank deposits, and CBSC?
Meaning central bank digital currency, I think you mean, yeah.
Yes.
The legal use cases, I'm out.
I mean, I think the person is referring to kind of the relative pros and cons of stablecoin versus, I think, just just fiat currency. I mean, I think one of the primary potential benefits is at least the potential for kind of speed of execution, and the ability to, well, I mean, the stable coins that I think the person probably is talking about are not ones that are programmable per se, and we can kind of get into the debate about a central bank digital currency, and I think there the pros and cons are pretty kind of have been detailed pretty extensively, both by industry and by the central banks that would be responsible for issuing them, and there are a lot of papers out there kind of discussing those, including potentially the impact on banking deposits and the concerns about the fact that the existence of central bank digital currency could result in draining of bank deposits, and certainly the banking industry has expressed concerns about what that may entail. I mean, I think that's kind of how I think about pros and cons. I don't know if you have any thoughts about that.
Yeah, I mean, I think it's more a question of people recognizing value in stable coins and wanting to use them as a medium of exchange. And I think that's going to be kind of a winner-take-all article phenomenon to a large extent, would be my guess. And I don't really know what's so different about that than, I mean, right now I have Bank of America dollars, and, I can use those to pay for things. So they're just entries in a ledger someplace, right? And who keeps the ledger and what the mechanisms and legalities are in terms of making changes to those ledgers and sub-ledgers that are associated with those. I don't know that stable coins will be any different than Bank of America.
Yeah, I mean, I
dollar
think
accounts, so.
I mean, my understanding is currently stablecoins are primarily being used to facilitate trading of cryptocurrency on centralized exchanges.
So now I will say something, not legal use cases, but saying something about the difference between these different forms of money. When stablecoins were invented, as I said, there are various flavors of them. And the idea in all cases seemed to be that if you're promising to pay dollars, the way to make sure that you can fulfill that promise is to have assets that are of the same or greater value, maybe even dollar-denominated assets of same or greater value. Now, and there were several flavors of this, and they're the algorithmic, and we're not going to get into all that. And we're testing all of that. Basically, all of these are not correct from a monetary point of view. That the question is par here. It's a liquidity question, not a solvency question. And so the analogy I would make is with the offshore Eurodollar system that trades at par, in cash markets, with the onshore US dollar system. And there's a whole sophisticated system of interbank clearing globally, and forward markets and interest rates can vary in Europe compared to the United States in order to create arbitrage when there's net settlement that is negative between offshore and onshore. And that's a very sophisticated system that is built up over time. We analogize in this paper that I was referencing, the BIS 1146 working paper. We analogize the stablecoin with Eurodollars in that regard and point out how primitive and fragile are the institutions that defend par between stablecoins and fiat money, as you call it. In fact, typically the stablecoin issuers are not promising to pay you Federal Reserve dollars, okay? That if you want to change your Tether into US dollars, you need to sell it, okay? Tether is not going to give you dollars. Bank of America is going to give you dollars, okay? So that is a quite important distinction that, that I wanted to make sure. Maybe that is a legal use case. I don't know if that qualifies. Do we have time for another question? Yeah? One more maybe from the...
I was just curious to hear your thoughts on, I know, Tim, you mentioned the UCC adoption last year with Article 12. I know some states had pushed back against that, saying it's going to usher in the era of CBDCs and payment observation by the federal government. That seems to me to be a point of tension that you guys touched on briefly, but maybe didn't go into more detail. And I'd be curious to hear your thoughts on that tension between the states, that concern, and the federal government.
Yeah, I
That
mean,
is you, Tim.
it's sort of it's funny because we were talking earlier. I mean, I think what's happened is that Bitcoin is kind of just claimed a little bit of the silver market in terms of, you know, the type of sort of speculative investment it is and how it's associated with this kind of libertarian thinking and antagonism towards fiat currency and big government and things like that. So, you know, it's crazy, I think, that people would avoid Article 12 because somehow they think that's kind of the nose under the tent for CBDCs. It deals with all sorts of things that are happening right now in our economy and how they get dealt with when you're sort of take paper out of and written signatures out of the equation and put in electronic records. And so it's too bad, but I just think it kind of sort of goes back to that propensity of people to have this, you know, anti-government libertarian views that have sort of existed, you know, out there for a long time, and they're now just, you know, say focused on Bitcoin instead of silver or something.
So it gives me great pleasure to introduce my friend and a woman whose imprint on American financial regulation will be felt for a very long time, Sheila Bair. I will introduce Sheila in a little bit of reverse chronology because I think it shows some of the breadth and depth of her experience and make her perfect for this conversation about the politics of financial regulation. Many will know that she served as chair of the FDIC during the financial crisis, during the moment in which confidence in the US banking and financial system was tested more so than at any moment from the Great Depression. She was in charge of the FDIC. But before that, she served as the Assistant Secretary for Financial Institutions in the Treasury Department at the beginning of the President Bush 43's administration, charting out and handling our response to the recession in 2001 and to the problems created by terrorism and the response therein, which was a different threat to our financial system, one that I can say as someone who lived through it, nobody woke up September 10th thinking about how our financial system needed to become resilient to the possibility of acts of terrorism. And, you know, pretty soon thereafter, that's all we were thinking about for a while. And before that, she worked in the Senate, leading financial services policy for the, I guess, both the majority and minority leader. And
Just majority.
just
Yep.
majority. Oh, that's even better,
Yeah.
just to serve there. For Majority Leader Senator Dole. And when you understand Congress, I think the old saying is the committees are the committees at work, but leadership is deciding what work gets done. And running that policy at that level gives you an entirely different perspective into the politics of it. So you have the legislative branch, you have the direct executive branch, you have the independent regulatory branch, which I still count as the executive branch,
Right.
but I think some are starting to create a fourth branch of government, I don't know, all coupled into one. So with that lengthy introduction, Sheila, let me get right to it.
Okay.
Right? Because you worked in the Senate as a Republican, you worked for the Republican president, Republican appointee, and people are fond of a simple narrative, right? Democrats regulate, Republicans deregulate. Reality is more complex than that. How would you describe it? in the politics of financial
Yeah,
regulation?
so I don't, well, I think financial regulation is becoming increasingly politicized, but in the past, at least, during my multi-decade career, it was really more, you know, community banks versus big banks. It was investment banks versus commercial banks. It was non-banks versus banks, credit unions versus banks. I mean, it was really the business model and kind of the sector of the financial system that drove a lot of the discussions. And there were, political parties. I think the Democrats were more aligned with the large regulated banks and certainly the GSEs. The Republicans are more aligned with private funds, hedge funds, private equity, and the smaller banks. And so there was a little bit of political alignment, but it was really more the fighting against the size and the business model. And I think, one of the issues that when we repealed Glass-Steagall, and we're not going back, so I don't pretend that we would, but you remember there used to be in the House, because I'm a bit older than you, but your institutional memory would encompass this. There was a House Banking, and there was Energy and Commerce that had securities, and Dingell, in the chair of the House Banking, would war it out because the investment banks served as a bit of a containment, political containment on the powers of the commercial banks and vice versa. So when you allowed them to combine, you didn't have that anymore, which I think has led to kind of exacerbated the too big to fail problem. And then, of course, under Mr. Clinton did many positive things, but there are a lot of the financial deregulation that contributed to the financial crisis occurred, especially on derivatives, occurred during the Clinton administration. So it's not the simple narrative is not accurate. And I think, and I don't want it to be accurate, because I think once you start politicizing it and marking these debates along political lines, you get away from the substance and what really good policy is, and that should drive the decision making, hopefully.
Yeah, no, I agree. I'm really torn to how you talk about the constituencies.
Right.
Because a lot of time people think parties are about, politics are about parties, but parties are really just sums of constituencies.
They are, that's true, yeah.
And as the constituencies have realigned themselves structurally as the economy has changed, that then has created different things. The idea of Democrats being friends with big banks, at the one hand, I kind of shudder to that. On the other hand, I kind of point out, there's a little bit of, there's definitely more than a kernel of truth in that. And there's the nature of the banking system has changed. If that's the history in the backdrop, we're going to enter into a presidential election, which at one point when we were planning this event, we said the primary season is going to be well underway and we won't know who all the nominations are. Not so sure I'd say that right now. I think it seems pretty clear that America's headed for something we haven't had since 1912, which is two former presidents, a sitting president and the immediate predecessor running against them. Now in 1912, America actually picked the third option, which and elected President Woodrow Wilson. But let's hold the third option aside for a second. We know in this presidential election, we've had 4 years of the Trump administration. We've seen who their financial regulators are. We've had 4 years of the Biden administration. We've seen their financial regulators. Is that how to think about this upcoming presidential election? How do you think about it?
Yeah, well, sir, let me start by saying Mr. Trump is no Teddy Roosevelt, so I don't. Your precedent is well taken, but and I'm obviously not a fan of Mr. Trump. So yeah, you look at what happened during the Trump years, and like in a lot of policy areas, his kind of more extremist rhetoric, and he actually had a lot of anti-bank, anti-Wall Street rhetoric getting elected. I don't think anybody believed that, and that really didn't prove itself.
He said he was going to reinstate Glass-Steagall.
Yeah. Well, that didn't happen. And you actually look at his trade policy; it was quite Wall Street friendly, because as the trade barriers were coming down with China on farming and whatever, Wall Street was all in. I mean, they had full access to China and actually grew their presence quite a bit. And then that has been curtailed somewhat now, but more because of China, not because of us. So there were some pretty Wall Street friendly policies on financial regulation. I know they certainly did some things that I disagreed with. I've known Randy for many years, and I think Randy unfortunately kind of became the personalized, focal point of some of the criticism of the Trump years for some regulatory easing. I didn't agree with a lot of it, but I do think it was incremental. I think it's important not to overstate. There was no massive deregulation of regional banks, for instance. I think there was some implication after the 3 regional bank failures last spring. It was incremental, and most of it I disagreed with, but it was not, it didn't just unravel completely the system. So I think it was somewhat overstated. Just as the criticisms now of the Biden appointees with Basel III endgame of massive overregulation and bureaucracy, I think that a lot of that is overstated. So consistent with the trend towards politicization of everything, we kind of cast each party in extremes, and I think that the truth is somewhat different. That said, if Mr. Trump is elected, and I hope that doesn't happen, I worry this time around. I think he was able to attract, you might disagree with him ideologically, but he attracted high-quality people. Again, you might disagree with the policies, but thoughtful, high-quality, knowledgeable people. This time around, I worry because he was so abusive to people who worked for him before. If he's elected, whether he'll be able to attract the same kind of person. And I also worry that it will be more, he just seems to have, to the extent there was an ethical compass there, it just seems like it's dissipated. And I worry about, frankly, corruption driving regulation, not policy, so it's, are you a MAGA person or not? And you're going to get what you want if you're a MAGA person. And we've been able to, through the independent regulatory process, we've been able to insulate most financial regulation from that approach. But I do think that's a broader concern, just given his rhetoric and who he is, and kind of you're with us and you're against us. And his decision-making seems to be driven by that, not necessarily what's good policy.
Yeah, it's interesting you say kind of neither side has been as radical as the other side
I
has.
would like to say they are, yeah.
And if you were to have put the names of the Trump administration regulators, and it is so name driven because I think in this space personnel is policy in a lot of way. If you put them on a board before 2016 and said, well, who is the Republican nominee? It could have been, I would have said, Mitch Daniels would have been more likely to appoint these people than.
Yeah, exactly.
So, let's get a little from the specific, let's get a little intellectual, right? This is the fun. We're at a law school and Brookings, and it's a .edu, and people talk about financial regulation and financial regulators as not political. I've always taken issue with that a little bit because I like to be precise with words. So let me read the definition of political, right? It is a defined term. It says it is, quote, relating to the government or the public affairs of a country, end quote. I can think of nothing more political than financial regulation under that definition.
Yeah.
I tend to think when people say political, what they actually mean is nonpartisan.
Mm-hmm.
And that means that agencies have institutional perspectives and institutional views that could be different, but are not inherently aligned with a party or a platform, but are very political, right? They are relating to the government or public affairs. How, from your experience, do you think financial regulators are not political, are not partisan? Are they both? Are they neither?
Yeah. Well, I think it is getting a little more politicized. I think they try not to be. I think the system, the structure is set up so that there's some level of independence, especially with banking regulators. They have independent funding sources. At least the Fed and the FDIC are governed by non-partisan boards. So I think, and even the SEC and the CFTC, though, that the chair serves at the pleasure of the president. They're not term limited the way the chairs of the Fed and the FDIC are. They're nonetheless fixed terms, and there's a requirement for nonpartisan representation. So I think it's built into how these agencies are structured, and I think that hopefully the people who are appointed to those jobs understand it. That said, the SEC and CFTC have become much more driven along partisan lines over the past several years, which saddens me. You said I was a commissioner, and for a while acting chairman of the CFTC too, so I understand that model. And I hope, and we saw some, unfortunately, partisan lines developing at the FDIC, though I hope desperately that we can get beyond that, because I think it's certainly the tradition of the FDIC not to be partisan, and that I always worked for unanimous votes. And again, back then it wasn't partisanship. It was, my gosh, John Dugan and I disagreed a lot. We were both Republicans, but he was more of a, big bank mindset, and I was kind of a more of a depositor, broader banking system mindset. So we had a lot of disagreements. But we worked it out 99.9% of the time, I think. And John, I will say, even though we disagreed, I think his input created better decision-making, and that's the model I think that's ideal. So I hope that continues, but I think it's worsening. And now you're seeing the Supreme Court erode some of the structural protections around independent regulatory agencies, whether it's the independence of agency funding, which is under challenge now with the CFPB, the Chevron, we saw the EPA case, and now the Chevron, deference, traditional deference to agency expertise is under assault. Term limits have basically been invalidated, or fixed terms have been invalidated to both the CFPB and the FHFA. So those directors now serve at the pleasure of the president. And so, structurally, we're seeing the system that's designed to insulate from political influence erode, and I think that's a big problem for longer term.
So I want to pick up on two themes of that about the structural system. The first is the chair versus the board, and the second is the increasing role of the judiciary.
Right.
So turning to the chair versus the board issue, it always struck me as interesting. There was a decision on a bipartisan basis. First, in the creation of FHFA, the Federal Housing Finance Authority, to regulate Fannie and Freddie and the federal home loan banks. They combined an agency that had a single head with an agency with a board. And there was a decision, a feeling that the GSEs, Fannie and Freddie, had been too politically powerful, and a board would be too weak. You needed one person, right? This was a Republican idea. It was signed into law by George Bush, one head. Similarly, the same on consumer financial protection, right? The Federal Reserve had been in charge of a lot of these rules for a long time. The board of the Fed had been dominated ideologically by, folks like Alan Greenspan, who said, you don't need to regulate subprime mortgages. The market will take care of itself. We saw the market did take care of itself, and the rest of us. And we wanted to have one single strong head, and that. And then the court is invalid. From your experience, and we still have a comptroller of the currencies. I think the last one is one agency head. It was my favorite Republican president, Abraham Lincoln, who signed that one. And maybe that'll go. I don't know. Yeah. What do you think? Do you think a board is better than a single head?
Yeah. Well, actually, I do. And I know that's not, and I supported the CFPB, but I did think a board structure would have been better. And I do think it can take longer to make decisions. You don't get the really forceful out there action that a lot of advocates want. But I think if you try to get consensus with your board, which I always tried to do, you have continuity and longevity of the decision making, which you don't get with single heads, particularly if, as now in two of our agencies, they serve at the pleasure of the president. So I had personal experience with that at the FHFA. I was chair of the Fannie Mae board when there was a transition in FHFA leadership. So when I joined the board, Mark Calabria was the head of FHFA. The Supreme Court invalidated the fixed term for the FHFA head, so he served at the pleasure of the president. So when Mr. Biden came in, he replaced him with Sandra Thompson, who I also know well. She worked with me at the FDIC when I was chair. So they're both really good people, high quality people, thoughtful people, policy driven people, but they had diametrically, So with Mark, it was shrink the GSEs, get them out of conservatorship, let's reduce their footprint, get them out of this conservatorship, which has been going on a ridiculously long time. With Sandra, reflective of the Biden administration, I think was, no, conservatorship is deep down on the list of things we want to get to, and we need to focus on affordable housing and increasing access. So they're just diametrically opposed, but it whipsawed the GSEs in a way that I think, neither one of them would have, I think, had the acuity of direction if there had been a board at the FHFA. Because FHFA, again, it can frustrate people because you don't get the same kind of forceful, decisive action some want, but it tempers the decision-making. It helps stay on an even course. And I do think continuity and predictability is important generally in a market-based economy, especially in financial regulation. And so I just use that as a personal example of why I do think boards are better. And I think at both the FDIC and the Fed too. I think the Fed I don't agree with a lot of what the Fed is on a monetary policy, but I do think they are one of the most, if not the most, nonpartisan entities. because they have this broad membership with very long fixed terms and longstanding, well-respected independents. And I think notwithstanding some of the rhetoric that's aimed at them, they pretty much ignore it and try to do what they think is right.
Well, it's a powerful argument we make on board. So I make a plug for last year's BU and Brookings event had both Mark Calabria and Director Thompson.
Oh, did you really? Wow. that was
In
great.
discussing the home loan bank system, because we want to hear from all sides of really smart, knowledgeable, credible
Right,
people.
absolutely, yeah.
And in that way, let's turn to the judicial thing, because to me, the Supreme Court invented out of whole cloth and right-wing fiction the distinction between a single agency head and a board as it relates to
Right.
executive power, and nullified these two structures that when we created had not been at all, when you write a law, and I worked on both laws, you think a lot about possible things that could hurt this law, including their constitutionality. Nobody said that. Yet here we are, we have a 6-3 Supreme Court, and this court seems aggressive. You mentioned Chevron deference, which is the kind of principle, which used to be a strong right-wing legal theory, which is now going to be overturned by the new right-wing
Right.
legal theory. Are we, and the first panel mentioned the growth of litigation in financial services. Are we going to see structurally over the next 5 to 10 years a new paradigm in which judges are putting themselves at the forefront of complex financial regulatory decisions?
Yeah. Well, it is ironic because Republicans have traditionally been opposed to activist judiciaries, and now, I think some of we have a more conservative judiciary that is somewhat being weaponized, I think, in the area of financial regulation. So that's not to say it's all bad. I mean, I think, the EPA case, we haven't talked about that. That's still sorting itself out, but requiring, some rigor around making sure regulatory decision makings fall within their legal authorities, and that they don't, go too crazy outside of that. I mean, the principle's not necessarily bad. Chevron makes me nervous, and maybe it's gone too far, but I do think, particularly in the area of financial regulation, this stuff is so hyper technical, and there's so much institutional, history behind how these rules got to where they are, that it makes me nervous if activist judges want to start rewriting those. But even now you're seeing BPI. I'll be talking with the head of BPI this afternoon, but you can ask him, whom I'd add was in the Clinton administration. So all right, I couldn't do that. No, Greg's a good guy. I've known him for a long time, but he is definitely a champion of the anti-regulation BPI forces right now, and they've been threatening, I believe, lawsuits, right, against the Basel III endgame. So it is, I think it's really not, I don't think we want the courts involved in this. And I do hope Republicans think, a lot of this stuff, what you advocate now is going to come back and bite you in 10 years. And I don't think we want an activist judiciary, particularly in the area of financial regulation, given the expertise that's required of it, and the fact that you have really high quality agencies already dealing with these issues.
So I know I could keep going on and on about this, and there are a bunch of more questions I have, particularly as it relates to the structural change between the legislative branch deferring more to the executive branch, to the regulators, and then the question of whether the judicial branch is going to take the deference of Congress and allow it to insert itself, because once upon a time Congress made some of these tougher choices.
Well, that's right.
And just hardwired numbers as opposed to hunting with greater discretion.
They did. Well, and if I could just add on the, so the CFPB's funding, the Consumer Financial Protection Bureau's funding, is independent funding sources that, which basically comes to the Fed, is under challenge now. But I was relieved, at least during the oral arguments, the more conservative, I mean, Congress clearly said this is what we want the funding structure to be. And I was pleased to hear some of the more conservative justices say, well, why do we want to, Congress can do that. Not everything has to be appropriated in an annual appropriations process. So why would we want to throw that out? So I think to that, there is some strain of conservatives still being a bit reluctant to overturn Congress when they made a pretty explicit decision like that.
Yeah, well, funding is, I think, is often an underappreciated arm of influence.
Oh, gosh, I was, when I was acting chair of the CFTC, which was appropriated, we were going through an appropriations process. It was a nightmare. And that was, you remember the Chicago Board of Trade. I mean, boy, those guys had a pack, but the Merck too, but I mean, the Chicago exchanges are notorious for bare knuckle lobbying, had these huge packs. They would just run that agency through the ringer during the appropriations process. Crazy writers about this and that, trying to nullify regs or, and some of it was personal too. And that was a problem with the old OFAO as well. The GSEs would do the same thing. So yes, independent funding. If you want independent agencies, you absolutely need independent funding.
So let me pause for questions from the audience. I see Khan. Yeah.
So your book, which I apologize should be on the screen, there for sales purposes, was aptly titled "Bull by the Horns."
Right.
Okay, and that's subject to many interpretations. Diversity, equity, inclusion are not words that trip off of one candidate's lips often.
Yeah.
Could you reflect with us for a little while here, not just about the politics, but the interactions of you as a woman
Right.
with bankers who are
Right.
still predominantly men and your peer regulators,
Yeah,
as
yeah.
you do in your book so elegantly?
Yeah. Well, I got that question a lot because during most of the crisis, I was, when Mr. Obama came in, we had, he appointed Mary Shapiro as chair of the SEC. So there was the bank regulators were still, except for me, male dominated. So yeah, and I had some well-publicized problems with with a couple of them. And so I was asked a lot, is this sex discrimination? And you never know. And I tell women, you can drive yourself crazy trying to think, is it my gender? Is it something else? And gosh, only knows. Just, I will say that, yes, I felt at times I was excluded from the right meeting, right? So I got invited to a meeting, but there had been another meeting before that in the hall or, in somebody's office or whatever, where the real decision was made and then was kind of like, and I would feel like I was being jammed sometimes. And I fought back and I pushed back because I don't want them to do this to me again. And I always, even if I go down, I'm gonna make it unpleasant for them. And usually by pushing back, I could get some changes in the decision, even though I think, the primary direction had already been set. And so I think this is why we need more women in all of these professions and including in agency leadership as well. And I tell women, you don't, just because you're a woman, you don't have to agree with another woman. We're going to disagree too, but at least stand up for their right to be heard, stand up for their right to be in that meeting, and stand up for their right to have their opinions be acknowledged, not just, held like dead silence follow, which typically can happen. So, but I think we've made a lot of progress, but it is important. And just having more, whether it's, a minority or gender or whatever, having a more diverse set of faces and perspectives in the room enhances decision-making, emboldens people, I think, and lets the others become more acceptive of those views coming from a more diverse decision-making body. Yeah.
Hold on a sec for the mic for the live stream.
So Sheila, I was wondering if we could go back to like 2008 and suppose you were Hank Paulson, Treasury Secretary. How would you have allowed Lehman to fail? But more generally, how would you have dealt with a crisis
Yeah.
over that period? My view of the crisis is that the Paulson and Bernanke basically made this panic much worse, that they actually didn't realize it was a panic. They were focused on fundamentals, everything screwed up.
Yeah.
But when ex post, when you look at the data, none of the things I'm alleging that the Financial Crisis Inquiry Commission claimed was the cause of the Great Recession has any basis in facts. When you look at what economists have shown, I'm not talking about any research I've done, just independent, a whole set
Yeah.
of studies suggest that all the allegations of, misrating and that the subprimes were all bad and that, yes, they were opaque, but that it was really panic at the heart of all this, and the instability of the banking system
Yeah.
fundamentally. But anyway, here you are, things have happened. You're Hank Paulson. You don't have any history with Fold from Goldman.
So how would you handle?
So I don't, I've written about, I think Bear Stearns was the original sin. I don't think they should have intervened with Bear Stearns. I think Bear Stearns could have found a buyer without them. Or, it was small enough, I'm not sure it would have been systemic to let it go down if that was what was going to happen. I don't think it would have. But anyway, they intervened. They provided government support for the JP Morgan Chase acquisition. And then I think Dick Fold thought he was going to get his bailout too. And he had opportunities over the summer to raise capital or to sell himself at very, very generous prices. He didn't want to acknowledge that his firm was not worth much at that point. But I think he just felt, if they didn't let Bear Stearns go down, they're not going to let me go down. I'm bigger, I'm more systemic than they are. And they did. So I think the surprise, that surprised the market. And you're right, by then things had been deteriorating such. This is the problem with, and I said the same thing on Silicon Valley Bank. I know some people, the argument there on bailing out the uninsured depositors was that it prevented a larger systemic run on uninsured deposits, but they had a run on uninsured deposits anyway. Declaring a $200 billion bank systemic and the need to bail out, and the optics of that were terrible, in itself created disquiet. So yeah, I think potentially exaggerating things, crisis is a very overused word. It is now, it was then. And the narrative around it, if I hear one more time, this is about poor people getting mortgages, I just want to scream. I mean, it was not, there's a whole nother conversation. It was an undercapitalized system. It was mainly in the investment banking, not the commercial banking space, and the large thrifts that were doing this. And the investment banks were too heavily reliant on overnight funding. And they had a lot of level 3 assets on their balance sheet. Nobody could figure out what the hell they were worth. These weren't just the baseline mortgage-backed securities. These were all the CDOs and CDO squares and all the structured finance that sat on top of these mortgages that magnified those losses, exponentially. The losses on the mortgages themselves was in the hundreds of billions. We could have absorbed that. It was the lack of transparency, the undercapitalization, and the reliance on short-term financing that gave it, that brought it to us. And yeah, I do think Bear Stearns started us down this road of bailout expectations that made things, I think it made things worse.
So bailouts beget bailouts.
They do.
And we've now bailed out everybody over COVID. And I would just
But COVID was nobody's fault, at least.
well, but I mean, why should a junk bondholder get redeemed
no,
at
it was
par
over
by
the
the Federal
top. It
Reserve
was over the
because
top.
there's a virus
Yeah.
that shut down the economy? I
That's
mean,
right.
they're if the holders of capital can never lose money,
Yeah.
then we do not have an economy, right? We have a perpetuity of wealth, right? So then the question is, under what scenario do the holders of capital lose money? And it seems as if, well, only if it's a few of them. If it's enough of them at once, then no one can lose. I would say, had we followed some of your ideas in 2001 and 2002, and there was some support in Congress for that too,
Yeah, they were.
we might not have had a financial system with as much opacity and as many toxic assets, as many things, but we went a different direction.
We did.
And we're going to have a different direction coming up in February, maybe, or in the end of this month, maybe not, but hopefully we can all learn and listen from some of your words of wisdom today. And if the audience can join me in thanking
Yeah, my pleasure. Thank
Sheila
you.
for sharing her thoughts with us today. And I think
Everyone, welcome back to the program. So we're going to get started with our next panel, which will be on ESG and moderated by Professor Jack Bierman of the Boston University School of Law, and he's going to introduce your panelists. Just a quick reminder to those who are joining us on the webinar, if you have questions for the panelists, please just enter them in the Q&A chat. We are monitoring it as we go along. Thank you, and a round of applause for our panelists.
Great. Well, thanks very much for asking me to be the moderator of this panel. It's a really interesting, important topic. Since I know very little about this subject, my job as moderator is to introduce the panelists and monitor their time and otherwise stay out of the way. So that's what I'm going to do. But first, I just do want to take a moment to congratulate our fabulous students, Marina and Connor, for putting this together, and they really make us proud. Our students all make us proud every day, and this is really one of those instances. And I also want to thank the Brookings Institution for its support and partnership. And I know the students were really anxious to keep this partnership going after it started up last year. So hopefully this will be a long-term thing, and it's largely because of Con Hurley's inspiration in the banking reform area here. So thank you. So I have the pleasure of introducing Pierluigi Matera, who I know from his time as a lecturer here. I think he comes in the fall, and I'm sorry that he's stuck in Italy, the poor guy, because he had a COVID diagnosis a while ago and couldn't get here on a flight. He's a professor at the Lus Rome and lectures here at BU, which is much more important. And we have John Gulliver, who's the director of the Committee on Capital Markets Regulation, and also the director of the International Financial Systems at Harvard. And then we have Jeremy Kress, who's an assistant professor of business law at the Business School at University of Michigan. They all have lots of credentials. It would take the whole 45 minutes to read them all off. I just want to say we're in for a treat, and I'll let Pierluigi take it away. John will go second, and Jeremy will go third.
Fantastic. Thank you very much, Jack. Allow me to join you to congratulate Connor and Marina for the excellent job and for the invitation. I'm really flattered. I had to postpone my flight twice, and I'm totally asymptomatic, but I still tested positive. So I'll be back over the next week, hopefully. But today I'm missing you all. I'm missing this great opportunity. So I'm sorry, I apologize if I am only via Zoom, but spiritually I'm there with you. And we had a correspondence over the previous days, and maybe to kick off the debate, some information and some consideration about what's happening in Europe can be, a good point to start. And more than talking about Europe, I would love to discuss and debate with you guys, friends, fellows, colleagues, students, well, the political and policy implication of European legislation for American companies. So for the American debate on ESG, because as you know, in December 2022, the European Union enacted a Corporate Sustainability Reporting Directive, CSRD. And later, around July, by the end of July 2023, they also adopted the reporting standard, to complement, to complete the directive. So now, these directives in force and will be applied gradually in 4 stages. We'll be discussing this later. And why this is so important? Okay, we have some reporting standards. It's very interesting. It's sustainability, so it's not climate-related reporting disclosure, but there is a provision which might affect the debate which is underway in the United States. And this provision is about the scope of the directive. So this directive, well, within the scope of this directive, some American companies might fall. And the application of this regulation to American companies, in my opinion, opens a debate. And it's a sort of, well, I might say the EU lawmaker through the American regulators a curveball, because now they set the standard, they are driving the way, and what's the option SEC and other regulators have in the United States? Now, one step back, what's this CSRD about? Now, it's basically some reporting standards which extends the non-financial reporting directive we already had in Europe. So a number of companies will be mandated to report on some sustainability, corporate sustainability information in a standardized way. Now, the notion itself it's pretty easy. Even the process which led to the adoption of this directive is pretty standard. So, we have the kind of cycle, the bottom-up cycle, the bottom-up dynamic, where we had people beginning to care increasingly about ESG issues, and then investors and stakeholders and consumers beginning to place great importance on understanding companies' ESG performances. Hence, companies began to recognize ESG relevance for reputation and ultimately, I would say, for the long-term financial stability. Therefore, the demand for sustainability disclosure began to grow exponentially, and this caused the need for the harmonization and persuaded the EU lawmakers to take action. That's the cycle, and it's pretty standard for this kind of regulation. What is pretty striking, even surprising, it's this provision on the scope, because this regulation will apply to American companies, to three categories, to three groups of American companies: large enterprises based in Europe, and including both companies listed on an EU regulated market and even companies not listed on an EU regulated market, but having operations or being based within the EU, as well as a subsidiary of US parent company. So there are some size criteria, but they're not huge. So you need to have at least two of the following criteria: greater than 20 million balance sheet euros, well, which is 21.4 as of yesterday, balance sheet, and more than 40 million net turnover, which is 43.9 US dollars, and greater than 250 employees. If you meet the two criteria, and even if you're not listed on an EU market and you are a US company, this directive, this regulation will apply to your company. Then you might say, okay, that's large enterprises, even small and medium-sized undertakings. So we call it SME. Well, the SME, according to pursuant to the notion we have in Europe, and again, we have some size criteria, some dimensional criteria, which are not huge. So we only should accept micro enterprises. Well, and then ultimately, even US-based companies that have no listing debt or securities, not listed the debt or securities on an EU regulated market, if they generate a net turnover of more than 150 million in each of the last 2 financial years, and have at least one large or listed subsidiary, or just a branch with more than 40 million net turnover in Europe, well, we have the application of CSRD. Now, why I'm boring you with all these groups? To convey one notion: this regulation will apply to a number of American companies. And I might say it will apply also to companies which are outside the scope of the directive. Why? Because since this directive is also about some information regarding the value chain, if you are operating upstream or downstream, you might be affected by these requirements. Because think of a private supplier to a public company that is subject to this CSRD regulation, reporting requirements. Now, this supplier may be asked to provide emission data to its customer, so that the customer is a filer, can make the required disclosure under the CSRD. Can you see how much this EU regulation can affect US companies? Now, it is true, we have some stages, because this regulation, which is already in force, but will apply gradually, starting from the financial year 2024, reporting 2025, and gradually small and middle-sized enterprises will have the possibility to postpone for 2 years the application, but then they will apply it. And the standards are very detailed and they're not very familiar for US companies. We have 12 standards, and these standards are sector agnostic. So they are good for any industry. Two are cross-cutting standards, so general requirements and general disclosure, and you must disclose, you must report about those standards according to those standards. And then we have 10 topical standards, 5 on the environment. This is important because then we can make the comparison what the SEC is proposing. So 5 on environment, 4 on social issues, and 1 on governance. So you can already see that European regulation is broader. It's not just climate related. Now, what's more standards are, which will be sector specific, are in the offing. So why this very big introduction? Because I would like to share with you one conclusion, this kind of reflection, which is this regulation has got standards which are different. Let's think of the double materiality. We have a double materiality, which is not like the notion of materiality we know pursuant to the US Supreme Court and Delaware Supreme Court case law. So companies shall report both on the impacts of the company's activities on people and the environment, so impact materiality, and how sustainability matters affect in terms of both risks and opportunities for the company's financial health, so financial materiality. This information will be audited. There is an assurance. It's a limited assurance, I know, but one day the EU lawmakers made that clear. One day we will shift to the reasonable assurance, the one we have for balance sheet and financial information, so that will be audited. The standards are very European, they're consistent with the European taxonomy. And finally, non-EU companies might be exempted if they report pursuant to equivalent standards or alternative standards, which will be one day possibly enacted by the EU legislature for non-EU companies. So now, what's happening? We have 3 levels of impact, in my opinion, for American companies. And I'd like to know your opinion about this. So we have US companies that fall within the scope of this regulation, and we'll have to gradually comply with it. We have US companies. Yes.
Luigi, we're getting short on time with the short.
Okay, yeah, that's the conclusion. Yes, that's the conclusion.
Okay,
that's
great.
totally the conclusion. That's the second point and third point. So companies outside the scope, but since they operate upstream or downstream in the value chain, they will be affected. And 3, Jack, in my opinion, even companies outside the scope, to stay competitive, they might comply with the European directive on a voluntary basis. Now, my question to you, my friends, is, now, the EU regulation will apply to American companies. Even if the SEC proposal gets approved, gets enacted, that kind of disclosure is climate related and is not equivalent to the European disclosure. So either the SEC and the American regulators set a standard which is equivalent or higher than the European standard, or even if we adopt in the United States the reporting requirements proposed by SEC, American companies will have to apply with different rules, with a different notion of materiality, the European law. I think this is pretty striking. And that's my question for you guys, and I'd like to know what you think about this.
Thank you very much indeed. Luigi. Thank you.
Thank you very much.
Okay, great. Now we'll hear from John.
Great, thank you. So I'm the executive director of the Committee on Capital Markets Regulation. We're a 501c3 organization that represents the interests of our members, and our members include the largest financial institutions in the country. So we're talking about the largest asset managers, the largest banks, the largest insurance companies, private equity funds, hedge funds, and we also have academic members, which kind of makes us unique. It makes us different than a trade organization, which is typically just advocating the positions of the largest banks exclusively or of the largest insurance companies exclusively. We really just focus on issues that have somewhat agreement across the financial sector and among our academic members. And these are kind of like the biggest picture issues for our financial system. Like, what's the right amount of capital for banks? You know, what disclosures should apply to public companies? And one of these issues is obviously ESG now. So what do I mean by ESG? You know, ESG is really 3 distinct things. It's environment, social, and social, really means diversity, equity, and inclusion issues, and then governance. And governance is kind of a long-standing issue. To what extent do the boards of directors really represent the best interests of shareholders in public companies? This has been a long-standing issue for financial regulation, but the E and the S are kind of new. So I think what we're really going to focus on today is the environment, not the social side of thing. And really, so the question there is, what is the role of financial regulation in promoting a green and sustainable economy? And I would say that's not a matter that is generally agreed upon in the United States. The left thinks there is an important role for financial regulation here, and the right in general is highly critical of a major role for the financial regulators here. So, there's different regulators, obviously, that have a different role. The SEC is very much focused on public companies and investment funds and the appropriate disclosures that should apply to both of them. And the Fed and the banking regulators, supervise the banks and try and maintain their safety and soundness. And what is the relationship between risks associated with climate and the safety and soundness? Or should banks be prioritizing loans to certain borrowers based on the impact of those borrowers on the climate? And those issues for the banks really aren't going to be my focus. And I'm going to keep it pretty brief and pretty high level so we can have an open discussion. My focus is really on the SEC, because the SEC is really heading in a direction of major change for public companies and for funds and what they have to disclose. And this has become hugely controversial. As the prior speaker mentioned, this is just at the proposal stage. So these rules don't apply yet. Right now, what public companies and public funds do here is largely voluntary. And it's actually increasingly common. So you'll see like Apple and the big tech companies and the big car companies, they disclose a lot about their impact on the environment, but they do so voluntarily for the most part. If that disclosure is material and has an impact on the financial performance of the company, then they have to disclose it. But that's a bit more narrow. That's not the mandatory disclosures are more limited now. What the SEC has proposed is going much further, and it would require all public companies to disclose their estimate of the impact of their activities on the climate, even if it doesn't have a material impact on their financial statement. So that's a really big change for the SEC, because the SEC has always been known as a regulator that only requires disclosure for what's going to have a material impact on the finances of a public company. So there's really two major elements of these mandatory disclosures that would apply to public companies. It's like, what are the emissions emitted by my power plants, or what are the emissions emitted in building the car? And then there's the second stage of disclosure, is what are the emissions associated with driving the car? So that's called scope 3 emissions, and the other ones are called scope 1 and scope 2 emissions. And the scope 3 emissions are extremely hard to estimate. So what the SEC has done is they said, okay, you've got to estimate, what they've proposed is you have to estimate scope 1 and scope 2. And if you get that wrong, you can be sued for getting that wrong. We can sue you, the SEC, or your shareholders can sue you. And for scope 3, there's no litigation risk, because we know it's so hard to estimate, what is the total emissions by all the cars produced by GM, or what are the emissions associated with everyone who and how they use their iPhones. So that's kind of the balance that the SEC has struck. What the committee has advocated for is that, at least for an initial period of time, we think there should be protection against liability for all of those disclosures, because it's going to take public companies a while to get those disclosures right. And if they get sued, that's going to be, that's obviously something their shareholders don't want. That's not good for the public companies. And more companies, in our view, will stay private and avoid public markets, because this is really expensive to do, and the litigation risk is really significant. So then the other issue right now coming out of the SEC is, what is an ESG fund, right? Because every fund lately wants to say, hey, I'm a green fund, come invest in me, because if you invest in my fund, you're part of making the world a better place. But it turns out that there's a lot of greenwashing going on, which basically means that a lot of these funds aren't actually really investing in green companies. Maybe they invest just a tiny little bit more in a green company and they decide to call themselves, a green fund. And that's really not good in terms of actually, moving forward climate goals. And it's also not good because it's misleading investors. So what the SEC has done here is try and create some minimum standard saying you have to meet these specific thresholds to call yourself a green fund. But our group has issues with what the SEC has done here because they've done this in a way without actually defining what a green fund is, and essentially defined a green fund imprecisely and so broadly that really any investment fund could qualify as a green fund. And we just think there needs to be clearer standards as to, a green fund needs to invest a specific percentage of their assets in companies that are actually focused on sustainable goals. So that's kind of a high level of where I see a lot of these financial regulation issues right now, specific to the SEC and disclosure.
Thank you, John. Thank you very much. Okay, Jeremy?
Great. Thanks, Jack. My name is Jeremy Kress. I come from Michigan. My background and my research is in banking and financial stability and systemic risk. But it's become impossible to think and write about banking and not address ESG issues. So today I'll give just a little potpourri of some hot ESG topics in banking and some ESG topics that are kicking around my head. But I think we've got a nice flow here with Pierluigi giving the EU perspective, John with the SEC perspective, and now I'll come at it from the banking angle. So I'll try to quickly address three topics that I think are highly relevant right now. One is state level anti-ESG rules for banks. The most prominent example is Texas. In 2021, Texas passed Senate Bills 13 and 19, which prohibit Texas municipalities from doing business with banks that do not do business with oil and gas and gun companies. Right. So Texas sent out all these surveys to banks saying, give us your ESG policies. And if you discriminate against oil and gas or gun companies, then you're not going to be able to underwrite municipal bonds anymore. So immediately after that, those laws were passed. 5 big banks, Citi, JP Morgan, Goldman Sachs, Bank of America, Fidelity, exited the market. Just last week, Texas legally barred Barclays, a 6th bank, from doing business with its municipalities because it refused to respond to the survey about its ESG policies. So this is tough situation for banks. It's also tough for the municipalities. There was an academic study Garrett and Ivanov released that showed in just the first 8 months after Texas passed those laws, it cost Texas taxpayers, Texas municipalities, an extra $500 million in interest and underwriting fees because there's less competition for municipal underwriting in Texas. If you're going to cut some banks out of the market, that eliminates competition and drives up prices for Texas municipalities and taxpayers. This is interesting to me because it looks what Texas is doing, and I should say it's not just Texas, right? There's 16 other states that have either passed or are considering similar legislation. Senator Kennedy in the US Senate has introduced a similar bill that would prevent the US government from doing business with banks that discriminate. He calls it the Red Banks, Blue Banks Act, right? No, we don't want red banks and blue banks. And it's interesting to me because it looks like a universal service mandate, right? Banks have to serve all comers consistent with safety and soundness and prudent underwriting standards. And if you don't serve all customers, you're going to be punished, right? And I think, to me, this highlights a real tension in modern banking because we have some aspects of our banking system that look a lot like a public utilities model, right? We've got the increasing prevalence of this quasi-universal service mandate. We've got well-established public backstops, right? The Federal Reserve discount window, all sorts of Federal Reserve lending facilities, fiscal backstops. It's clear that there's a public backstop. We won't let banks or the banking system fail. That looks like a public utility. And yet other aspects of the system, right? Strong opposition to safety and soundness rules. You'll hear from the Bank Policy Institute later today, right? God forbid we should increase capital requirements. Other aspects of the system that don't look at all like public utilities, the unlimited asymmetric upside for private bank shareholders. That's not at all public utility model. So I think I'm trying to suggest that our current conception of banking, we don't have a coherent conception of banking. Some aspects look like public utilities. Some aspects look like private capitalist owned system. I'm not sure that Texas is wrong, right? I don't like oil and gas companies. I don't like gun companies. I'd prefer if they didn't have easy access to capital. But I think, in this respect, I'm inspired by my colleagues, Lev Menand and Morgan Ricks, who've written about banking as a public utility. I think they're right that the historical conception of the US banking system is one of a public utility. And I think banks probably should serve all customers if we were to redesign the system, it would be one that looks more like a public utility system, but that's not what we have today. So I think in order to increase coherence, I think we ought to move one way or the other. I hope it would be in the public utility model, in which case I'm perfectly fine with a universal service mandate as long as it comes with appropriate prudential regulation and some sorts of caps on shareholder returns. So that's kind of topic one, those state level laws. Another relevant ESG topic, that was environment and social. This is trending more towards in the governance arena. FDIC Director Jonathan McKernan gave an interesting speech earlier in January about the big three index fund managers and their influence over banks' ESG policies. McKernan says BlackRock and Vanguard and Fidelity collectively own large interests in all the big banks. And he worries that the index fund managers are pressuring banks to do things like cut off oil and gas companies or cut off gun companies. And he thinks that this is a potential violation of a bunch of banking laws. The Bank Holding Company Act, for example, prohibits shareholders from exerting a controlling influence over the management of a bank. If you do exert a controlling influence, you yourself become a bank holding company, you're subject to Bank Holding Company Act regulation. I think as a matter of law, he's not wrong, right? If what Fidelity and Vanguard and BlackRock are doing is trying to influence the bank's ESG policies, then that looks like controlling influence, and maybe that pushes them into Bank Holding Company Act territory. So as a descriptive matter, he may be correct. I think my pushback is on a normative matter. That might be a good thing, right? We may want to live in a world where diversified shareholders have more of an influence over the policies, especially of large banking organizations. Because if you consider the alternative, where we have concentrated shareholders, again, with unlimited asymmetric upside, concentrating holdings in individual banks, you would expect them, because of their asymmetric upside, to prefer riskier management strategies versus diversified shareholders like the big asset managers who not only own shares in Bank of America and JP Morgan and Citi, but also own large stakes in car manufacturers and tech companies and healthcare companies. I worry that empowering concentrated shareholders leads to more systemic risk and frankly worse ESG outcomes than allowing these large diversified asset managers, who should have the best interests of the macroeconomy on behalf of all industries, because they're large shareholders in all industries. I think we perhaps might want to live in that world and empower those shareholders with more diverse interests to exert some influence over the management of a bank. Banking law right now doesn't not allow that, but I think from a normative perspective, we may want to move there. I will say, I gather I'm running out of time. Let me just mention one last governance topic that's on my head right now. Conflicts of interest are still pervasive in finance, and they're particularly pervasive in banking. Next week, there's a comment period ending on an FDIC corporate governance proposal that, among other things, would try to reduce conflicts of interest in the governance of bank holding companies vis-a-vis their depository institutions. Right now, and this is an area I've researched, there's almost perfect overlap between the boards of directors of all the largest banks and their holding companies. As I've written about, I think that leads to some perverse incentives for those directors to allow holding companies and their non-bank subsidiaries to take advantage of the subsidies that depository institutions get. So next week, I'll be commenting in support of the FDIC's proposal that would not require, because it's guidance, but it would strongly urge depository institutions to have a majority of their board of directors be people who are unaffiliated with the holding company and its non-bank affiliates. So I will tell the FDIC that it should finalize that proposal. I will simultaneously file a petition for rulemaking with the Federal Reserve in the OCC, asking them to adopt a similar requirement, because I think the governance and the reduction of conflicts of interest is a really important topic.
Great, thank you. Now, do we have any, I'd like to allow very brief responses of the panelists to each other, like 1 minute. So that we
Yeah,
can then
I'd
go
love, I'd love to react to a couple of Jeremy's comments. Very interesting. And I guess my points are, the first one on what I call the state crossfire issue. So you've got your red states, you know, pushing all of the banks that operate there in a direction that's consistent with their political views, and you got blue states kind of doing the same thing. And I think there's an argument, and this is something the committee's looking at now, that this could ultimately be unconstitutional because it discourages interstate commerce, right? Because you can see a logical outcome eventually if we keep going down this direction, that all the banks in Texas have to be red banks and all the banks in New York have to be blue banks and only lend to the borrowers that are sort of approved in those states. And that's just bad for the country. And I think, you know, interstate commerce is something that is supported by the Constitution. And there's been Supreme Court cases on this recently, and they haven't come out in a direction that is actually good for this argument, because it is a right-leaning Supreme Court. But I don't think it's ruled out entirely that there is an extent to which it could become so restrictive to operate in red or blue states that the Constitution might prohibit states from going too far in this direction. And then the other point I had was on the large asset managers and their role in corporate governance in America generally. And this has become incredibly political. And if the administration is Republican in a year from now, you are going to see a major attack on BlackRock, on Fidelity, on State Street, because in general, they're associated with pushing more pro ESG. And like I said, the left loves that, and the right really doesn't like that. So the right is going to try and crack down and you know, impose a variety of restrictions on the large asset managers to start voting their shares in public companies in a way that's more consistent with, you know, either the interests of the right or what they believe is in fact should be the priority for those asset managers. But these asset managers are very smart, and they see this coming, and they don't really necessarily want to be in the middle of this debate, because they're also losing business. So you see states like Texas pulling out of BlackRock's funds. You know, they're saying, well, hey, we're not going to put our money with BlackRock because, you know, Larry Fink believes in ESG and, you know, we don't. So what the large asset managers have done is implement pass-through voting, or they're in the early stages of doing this. BlackRock is a bit further ahead than the rest. And this basically says, look, we don't want to take a position on sustainable goals, and we want to actually vote our shares how our investors want. So we're just going to pass through that right to you, so Texas can vote their shares whatever direction they want on sustainable issues, and New York, you know, the retirement system of New York can vote whatever they want on sustainable issues. So then they're kind of taking themselves out of that debate, which I think is a good thing. There are limits to the extent to which that can be a solution. Because, well, what about the retail shareholders, right? Because retail is not going to look at all of the votes for all of the public companies held by their S&P 500 fund. That's just not realistic. They've got some early ideas about polling retail. Poll the retail investors in Texas and see how they want to vote. Poll the retail investors in New York, see how they want to vote and act accordingly. But that's really early stages. But anyway, so those are a few of the issues that.
Is there anything else before we turn it over to the, very brief, before we turn it over to the audience?
Yeah, if I could, thanks, John, for your comments and recognizing that I am in no way a securities lawyer. But one pushback I often hear from the left on types of comments you made with respect to the SEC disclosures rule is that investors want this information. If you look at the comment letters on the SEC's proposal, nearly uniformly, the investors say, yes, we want these ESG disclosures. Is that not indicative that this information is material, that reasonable investors want it?
Okay, Pierre Louisi, did you have something brief? No? Okay, you're good. Okay, how about from the audience? Yes, we're going to bring the microphone up. I guess we'll give Khan the home court privilege and let him go first.
I'm a little surprised that the term shareholder capitalism and stakeholder capitalism hasn't arisen in this discussion. So I'll ask you, if anyone of you is aware of the public benefit corporation, B Corp, benefit corp model, and how that plays into your discussion of all of these issues, because there are some banks that are organized as B Corps.
Yeah, it's a great question, and I think the public utility model that I suggested looks a lot more like a B Corp than what we have today, and I think that consistent with what Manand and Ricks have written, that's the historical conception of where we came from in U.S. banking history, and we've made choices as a country that deviates from it. You see isolated examples of banks that adopt this public serving mission, serving other stakeholders beyond just their shareholders, but it really is an isolated example. Of course, you have the credit union model, which also looks a whole lot like the stakeholder capitalism model. I go back and forth in my head between whether some days I think that all depository institutions should be credit unions, and some days I think we should abolish the credit union charter. I see Aaron laughing because I'm sure he has opinions on this. But it's an uneasy fit because there is a diversity, and it seems like the stakeholder capitalism model is by and large winning, and it's tough to undo once you go down that road.
Also for Professor Kress, along the lines of the public utility model, what would you see as regulatory moves in that direction?
Mm-hmm. Yeah, so I would just commend to you the paper that Morgan and Lev wrote, Banks as Public Utilities. They've got a few quick steps that you would need to do. It would involve things like geographic licenses, right? You would allocate areas for different banks to serve, so you get a more locally focused banking system. It would involve rate caps, so not unlimited rates of return for shareholders. That would substitute for their deposit insurance assessments, right? You would just cap the rate of return, and everything else would go back to the FDIC or the Treasury. But this is really their intellectual groundwork, and so I just commend their work to you.
Oh, good. Online questions. First time listener.
Okay, so this is a question from one of the participants on the webinar. Would the Texas issue go away if asset managers removed the reference to oil and guns and replaced it with a risk-based approach?
It's a good question. I don't think so. I think it was really a matter of, the asset managers have already adjusted the way that they talk about these issues, and the issue really hasn't gone away yet. Like, there was an article in the Wall Street Journal a couple of weeks ago which just said ESG is now a dirty word in corporate America. Because if you look at the disclosures from quarterly earnings reports, it used to be every CEO of a public company was touting, their ESG goals and their greening, and now no one's really saying that because this has become so political. So I don't think just changing the language a little bit is really going to have this go away. I think need to be more than that.
I'm going to chime in as a constitutional law teacher on the Dormant Commerce Clause issue and just say that, I think it would be really striking if the Supreme Court started telling state and local governments where they can and cannot invest. And I would think that if the Congress wants to step in using its power to regulate commerce, that's one thing. But for the Supreme Court, for let's say a bare majority of the Supreme Court to decide a major issue of policy like this, I think it would be really an inappropriate use of their power. And I think, I'm sort of with Justice Thomas on the Dormant Commerce Clause, which is that it's a fiction that ought to be abolished at the first possible moment. But barring that, I think they ought to be really cautious in making an intervention into such a highly political and consequential issue for the financial system of the country.
So I'd like to follow up on that. So is there an extreme though, where you would say that this actually could pose a constitutional issue? Like in your view, can Texas essentially say, we will only have red banks and and then New York, can they do the same? Like, do they?
I think the constitutional issue would actually go the other way. That maybe if Congress tried to tell Texas who they had to invest in, that Texas might rely on the 10th Amendment and federalism and say, you can't tell us that if we want to run our market the way we want to run our market, there's no federal business in here. And so I think that if there's any constitutional weight, it goes in the other direction. And so the courts certainly shouldn't do anything, and Congress ought to be very cautious in interfering with the financial decisions of states and local governments.
So you do then think that Texas could essentially bar all non-Texas banks that are,
Well, they can't say non-Texas, probably. Yeah. There's also the Privileges and Immunities Clause, but I do think that as much as I'm sympathetic to ESG, and I think that the best thing that could happen for Texas would be to get a different government, but I do think that if Texas wants to do that, if the people of Texas want to do that, and the government of Texas wants to do that, that no one else should really be able to tell them that they can't. Neither the Supreme Court nor Congress, certainly not the Supreme Court.
Wrap up the panel. So last question. Digital global mobile speed to market creates a gap between internal operation clock and external market clock. So how realistic is it to meet more requirements like ESG compliance requirements without shortcuts?
Sounds like a good question for
Here, Luigi, what do you think? Are those very sort of moderate, easy to fill out forms that the EU is proposing? Is that something that's going to be a problem for the quick action that often is necessary in the financial markets?
Jack, there is panic over the new standards. I must be clear, and even more panic for my US companies, my clients from the US, they phone me, what are going to do? So this is going to be additional costs, and we know that we have, the European way is auditors, because we will have the assurance, so those data will be audited. So, hopefully, I believe those information and that kind of compliance it's a great business for the big fours and consultant companies. And that's a point. I would like also to add, when you discussed, someone put a question on, I couldn't see, on stakeholderism and shareholderism and ESG. Now, I do believe that we have different levels. On one level, we have the question, shall we disclose on ESG? And actually, we already do part of it because we already have some non-financial disclosure requirements. So shall we standardize that kind of disclosure? And yes, as my colleagues pointed out, otherwise we're going to have greenwashing. And third, stakeholderism, in a sense, at least in the European debate, we believe it's a bit overstated. Stakeholderism is politically overstated, and you know why? Because when a company advance a green agenda, you do that because yes, you are trying, because you know that you will be reporting on that. but also because you're trying to make your reputation better, to sell your product, to sell your services. Otherwise, the market is going to punish you. So that's advancing shareholder value. That's advancing the interests of your stockholders, not your stakeholders. And of course, you do good to the environment, which is great as well. But you pursue that kind of agenda, not outside the shareholderism. You are still in the perimeter of shareholderism. So stakeholderism should mean I pursue a stakeholder interest which is totally against my shareholders, okay, and gives no benefit whatsoever to the company's reputation, to my market share, and to anything else. And I just can see that. It's like you do charity in a very hidden way. You don't want people know it, possibly, but I just cannot come up with a credible example where you pursue stakeholderism in a way which is totally against shareholderism in these ESG reporting requirements. Well, not a theoretical example. So if we talk about stakeholderism, shareholderism related to ESG, we should also consider that practically, well, on a practical side level, well, you know, the room, the space for stakeholderism is very little. So sometimes I believe that kind of debate is a bit political, more so that they take some stance for political reasons more than for, you know, concrete practical reasons. And that was my point.
Great. Well, thank you very much. And thanks to this excellent panel for enlightening us on some of the current issues on ESG.
Hi, everybody. Welcome back. So our final panel of the day will consider the role politics may play in bank capital, deposit insurance, and systemic risk. Our moderator for this panel is Professor Cornelius Hurley of the Boston University School of Law. Our panelists are Aaron Klein, Senior Fellow at the Brookings Institution, Greg Baer, President and CEO at the Bank Policy Institute, and Professor Lawrence Kotlikoff of the Boston University Department of Economics.
Thank you, Marina, and thank you, Connor, and Chelsea, and Ms. SC, and a whole review of banking and financial law staff, and to my colleague, Aaron Klein here. This is the second year of our jointly sponsoring a symposium like this, and as Aaron mentioned earlier, last year's symposium could not have been more timely in terms of what is going on in the world. Our last year's symposium was February 10th. A month to the day after that, a bank by the name of Silicon Valley failed, and the fingerprints of the home loan bank system were all over it. 2 days after that, Signature Bank failed, and the fingerprints of the home loan bank system were all over that. And then a month later, First Republic failed, and you kind of get the narrative anyway. It's delightful to have this partnership with Brookings. First of all, to those in the audience, thank you for being here. A panel after lunch, you deserve some kind of an award. I don't have anything for you other than the pudding is delicious. I recommend that.
There's a lot of it.
And there's a lot of it. And to our friends online, the 600 or so of them that are listening in, I want to talk a little bit about diversity. I know this is pretty much old white men, or at least old in my case, and it wasn't for lack of trying, Marina, that the panels have been a little skewed. We are going to do better next year. Try harder. Can you promise to deliver us Janet Yellen next year? Oh, good. Sheila Bair was nice, but we need more Sheila Bairs in the world. My hope is that 20 years from now, when we're talking about the financial crisis of 2024, this panel will be filled with women who screwed up in their jobs as CEOs or as regulators. Right? A brief introduction. These are all my friends, and you'll understand why. I cannot resist this. One of the members of this panel got up this morning and got dressed only to find out that he was wearing not what he is wearing now, but a tuxedo, having gotten dressed in the dark. Now, I'm not going to out who that was. If he wants to out himself, that is totally fine. But I'll give you an idea of how focused we are on the subject matter at hand. I thought what we'd do is divide this into two parts. One is the chewable, enjoyable politics part of it, which I know you are good at, and you are good at, and Larry is certainly good at. Then we'll talk about capital, which is the name of the panel. And then finally, we'll make, hopefully, some predictions about the next Congress, maybe the next administration, and the consequences of that. The panel on the far left is, his name is Jimmy Stewart. Oh, no, I'm sorry, Jimmy Stewart is dead. And Jimmy Stewart is Dead is the name of his book, coincidentally, right?
Well, yeah.
Yes. And that is available on Amazon if anyone wants to buy. Jimmy Stewart is Dead by Professor Lawrence Kotlikoff. He and I have been colleagues here at BU for 20 years at least. And he is an expert on all things financial services related, but particularly on retirement planning and Social Security. So maybe he can weigh in on what the future administration means for Social Security. Greg Baer and I are both alumni of the Federal Reserve Board Legal Division, right? Greg is a guy that I am supposed to hate. We're all supposed to hate him because he is the face and voice of the too big to fail banks and more, right? But
they're not actually too big to fail.
Pardon me?
They're not too big to fail.
But he expresses himself and represents the industry with such a kind and logical and intelligent demeanor that it's hard to hate him, right? So I'm working on it, Greg, okay? And I'm sure after you hear from him today, you'll know why I say that. What can I say about Aaron Klein? Aaron Klein, you haven't written a book yet, have you? No, but if you
and I'm easy to hate.
No, but
I've written 2 books.
If you were just to Google Aaron Klein and print out all of his comments in the media over the last 20 years, you would have a very informative book that would tell the history of financial services over that span of time. So I recommend you do that. We think that politics today is as raw and divided as it can be. It's 1936. It's the eve of the election. It's Madison Square Garden. And the then President of the United States says to a full house, "The bankers of this country hate me." And then he says, and it brings the house down, "And I welcome their hatred." 1936. This is the FDR who gave us the FDIC just a couple of years before. My first question is for Greg. Do the bankers hate the Biden administration?
Well, it's a big administration. I mean, there's a Department of Agriculture. I think it's fair to say that there's been pretty significant disappointment in a lot of the proposals that have come out, and sort of the vitriol with which some of them have been delivered, particularly in the consumer area. Junk fees, fat cat bankers. The sort of invective that I don't use when I talk about these issues, and traditionally no one really has. So I think that's been deeply unfortunate. There's still a lot of very professional people working at the agencies. I mean, you can overstate the influence of an administration on bank policy. It's actually probably as insulated from electoral politics as just about anything, in the sense that you have career staff at all of these agencies, primarily the Fed, having been one, as you note. And pretty much the staff has a lot of responsibility for the outcome. So it's not like some other parts of the government, but certainly around the margins, I think you've seen some proposals that are very difficult to justify, sort of on data or analytical terms. We'll talk about capital, but then also delivered with a level of rhetoric that we haven't really seen.
So looking forward a bit, is there a horse in the race?
In which race?
In the presidential sweepstakes?
Oh, I don't do presidential sweepstakes. It's a difficult thing to even imagine.
I thought I might catch you at a weak moment.
No,
Yeah.
I got enough problems trying to predict presidential races.
But Aaron has a theory of the case, which I just love. And we all love analogies to physics. And Aaron has been through enough swings in the pendulum now to see where the pendulum is about to center. Tell us the theory of your case.
So this is the common analogy that there's a regulation occurs after a financial crisis. That regulation overshoots, deregulation then picks up steam, deregulation overshoots, and then there's another financial crisis. And this gives rise to this pendulum metaphor, which you'll hear frequently when discussing the politics of financial regulation. And I think, like many things, the metaphor is deeply flawed. And when you start to constrain yourself into a deeply flawed metaphor, you then find yourself making a series of intellectual mistakes because your predicates are wrong. So a pendulum, right, one has an equilibrium center. That means that there's some magic point where the pendulum will be at rest and stay at rest if it's not otherwise disturbed. I don't think that's true about financial regulation. I think the optimal point of financial regulation is a moving target depending on many other areas of the economy. Two, the laws of physics with a pendulum show that we'll swing proportionally. Pull it back, have it go forward. The hidden metaphor then is both the regulatory and deregulatory shoots are somehow symmetric. There's no evidence to that point, right? In point of fact, one of the big conversations you've seen is this argument that the deregulation in the Trump administration, known often by its bill title S-2155, had something to do with the bank failures in the spring. I've studied it very conclusively. No, it didn't. There's nothing in that deregulatory thing that at all dealt with the set of problems, right? If that law had or hadn't passed, SVB would have occurred in basically the exact same way, right? And so I think instead of thinking of this physics pendulum with a magic equilibrium and a symmetry to it, right, we ought to be thinking in a very kind of, so I think that's just a junk framework, right? Two, then the question is, okay, Aaron, you've trashed the generic framework. What would be a better framework? And this is difficult. The metaphors here are a little bit wrong, but I'll pick one topic, which I know you said we're going to go to in a bit, but it is the title of the panel, which is bank capital, right? So bank capital has two different possibilities. You have risk-based capital, which economists tend to love because it's a complex model, and if you can figure out the right risk and equivalate it correctly, then you can get a good market, right? It should be in theory more accurate, but its flaws if you have the wrong definition of risk, you botch your model, whether you under risk something or over risk something. This current Basel III debate is about over risking. Subprime mortgages were about under risking. The second option is simple leverage ratio. This is historically what the FDIC is liked, and the benefit of simple leverage ratio is the first word of it. Simple. However much you have, you hold 10% capital, 8%, 12%. We can debate the percent. It's transparent and it's ungameable. It's also incentivizes risky behavior because as Greg has taught me many times over, right? If you have to have 10% capital and you're trying to maximize return on equity and you're a shareholder, but not a debt holder, and ultimately as the insurer, the taxpayer, the US government is the ultimate backstop of insured depository institutions, one set of their liabilities, of their deposit liabilities. you're going to maximize return on equity and you're going to lean towards riskier behavior, which is in and of itself. So you have two things that are flawed. All right. I tend to like a metaphor of this with chopsticks. If you give me two chopsticks, I can use them together and eat. If you give me one chopstick, I'm just stabbing at something. Instead, what you find in Washington is that you pick a camp and then you're for that camp. And whenever the other capital measure is binding, there's a problem because your preferred measure isn't binding. You think there's a problem in the model and you want to either change yours so that you have the binding constraint, and the two sides aren't comfortable with what I think is the natural equilibria, which is over the course of an economic cycle, the two different constraints take turns being binding. Now, and so that's how I use it as a chopstick metaphor. Now that's only in capital regulation. There are other metaphors and other points, and I'll close by saying it's precisely because regulation has to be thought of in the context of what you're regulating that it's not a one metaphor fit all size. And so this idea of a pendulum and deregulation and re-regulation assumes all regulation is somewhat similar. And in point of fact, I disagree with that. Some regulation is more important than others, and some regulation serves very different purposes so that you would want to be asymmetric in over or undershooting.
So while we're on metaphors, we've gone through pendulums and chopsticks. Larry Kotlikoff, his metaphor is the hourglass. And by Larry's calculation, we're 15 years out from the last great financial crisis, and we are about due for another one. If I read you correctly, Larry?
Yeah, so we have, think about the BU bridge here. We've built it in a way that it can collapse. Let's suppose that we've built it in a way that it could collapse because it was designed by members of Congress. And then they set up a huge regulatory system where they have inspectors who make a lot of money, and they have lawyers that interact, and you have this entire edifice. But there's another way to build the bridge, and it could have been so that it would never collapse. And that's just in reference to this book, Jimmy Stewart is Dead. You can, if you want to read that, you can see what I'm talking about there, how to build it without collapse. But here's the thing. The bridge has collapsed. It collapsed 15, if you go back to last March, 10th, 11th, when Silicon Valley Bank collapsed, that was almost exactly 15 years to the day that Bear Stearns collapsed. And if you go back to the beginning of the country, every 15 years on average, we've had a financial crisis. The question is, so what we're doing here isn't working, and it's not really been working of late either. So there's this notion that, well, if you just put in the right extra bolts in this bridge, it's going to keep it fine, and that'll be good. Or just every so often, just make these adjustments, and it will never completely fall apart. But that's not really the truth. The truth is that the thing could collapse entirely. And we saw that last March when we saw that there was a run, as Sheila said, on uninsured deposits. They right now represent 7 out of $17 trillion. And it was just really, I think, luck that not all 7 trillion uninsured deposits ran against the banks that held those, many of which were small and regional, because we would have had massive bank failures. As it was, we had the second, third, and fourth largest bank failures in US history occur within a couple months. And collectively, they were much bigger than Washington Mutual, which was the biggest bank failure in the that had ever occurred in the US, and that happened in 2007, I believe, or 8, I guess it was. I'm not sure. It was at the end of 2008. So the point is that we have to think bigger, I think, about what's going on. The politicians, I think, on both sides are being paid off by the bankers. If you look at who's contributing to the members of the House Financial Services Committee, they're all the big banks. There's this, revolving door here. Barney Frank, who co-authored the Dodd-Frank bill, he went off to work for Signature Bank, which was one of those 3 banks that just failed. Something's not right here. Should I stop or go on?
Finish the thought.
I do want to say that I didn't actually put on my tuxedo. I put it in my suitcase because I live in Providence in the dark, so I wouldn't wake up my wife. I thought it was my sports jacket, and then I opened up my suitcase this morning to find out that it was a tuxedo and not my sports jacket. Just to be clear, not quite that daft yet. So we could have conversations till we're blue in the face, and we've had these conversations at different levels of agencies here and internationally about what exactly the right capital ratio is, and what the right formula, and how to how to risk weight different assets. And it won't really matter at all in terms of keeping us safe, because if what happens in these financial crises is not that the regulators got a little bit wrong. What happens is that you go to panic, that the economy, the banking system, and the economy more generally has, I think, multiple places it can go to, what we economists call multiple equilibria. And that you see that when panic sets in, it doesn't matter how much capital you have, it's not going to be enough. It's just like you can't be a little bit pregnant, you can't be a little bit leveraged. So I think the only way to really keep that bridge from collapsing for sure is to make sure we have 100% capital so that we have no leverage. That doesn't mean we have a financial system that doesn't operate. I think we can have a financial system that operates without leverage, but the entities that need leverage, which are the households and the non-financial sector, they're leveraged, but the intermediaries, they don't need to be leveraged. They don't need to be gambling with other people's money, which I think is also a line from FDR.
So what Larry is describing is a bank like a money market mutual fund, which is 100% equity, no risk.
Money market mutual funds are massively levered and repeatedly bailed out.
Well, I'm talking about, so let me just follow up on this. I'm talking about, there are 100% equity financed mutual funds, money market funds. In the Great Recession, we had 10,000 mutual funds. About 3,000 were leveraged in the sense that they claimed to be back to the buck. They got bailed out. They're less leveraged in that respect today because of changes in back to the buck provision or law, or ability to do that. But the other 7,000 mutual funds, like Fidelity's Freedom Fund or Magellan Fund or the Index Fund, we were talking about Vanguard has, none of these funds had any financial problems in the sense that none of them collapsed. They were all, so we had a financial hurricane or whatever, tsunami, and the banks, the financial institutions were built out of brick, did not collapse. The ones built out of straw collapsed, and then we rebuilt everything back out of straw under Dodd-Frank.
So Greg, I'm sitting at home, minding my business, watching TV, and on comes an ad telling me that the proposed capital rules coming out of Washington are going to eliminate jobs, lending to small businesses and minority communities and all of this stuff. Scared the crap out of me, right? I've never heard of a proposed regulation being the subject of a national advertising campaign. Can you tell us a little bit what's behind that?
Well, I mean, what's interesting in this case of this proposal is I think you're not just hearing that from banks, you're actually hearing that from small businesses. If you haven't been following, and if you look at, I think 97% of the comment letters on this proposal were adverse. That includes comments from small business groups, civil rights groups, community groups, the buy side, so pension funds, mutual fund investors, the securitization industry. So all of them seem to have clued in that if you significantly raise bank capital, that they are going to end up paying more for credit or capital market access, and that should matter to them. So that's been something of an epiphany and a real change of approach, which is great. If you think about the proposal, it's an implementation of a Basel agreement in 2017. When the agreement was announced, they said there would be no increase in capital requirements. They issued a quantitative impact study indicating there would be no increase in capital requirements. The Bank of England has implemented that last couple of months with a 3% increase in capital requirements. Since 2017, the US financial services sector has performed terrifically well. The largest, most diversified firms actually took in massive market share after Silicon Valley Bank. They were not in any sense endangered. I think neither were the vast majority of regional banks, because they didn't fund themselves like Silicon Valley Bank did, and they didn't go long on rates at a time when the Fed was about to increase rates significantly. The proposal estimated there would be a 16% increase in capital requirements. The real number is probably closer to 20. I think they're going to admit that pretty soon. For the largest banks, it's closer to 30. For capital markets, it's a 75% increase in capital, even though all of the relevant banks have radically diminished risk in capital markets and increased their capital post-crisis. Actually, aggregate tripled capital since crisis. And so, in the wake of a real-world test, COVID, et cetera, where all of the banks seem to have plenty of capital, where Treasury secretaries and Fed chairs across multiple administrations have said that the industry is well capitalized. When you're implementing a Basel agreement that was predicated on capital not going up, to come out and say, well, actually, every large bank in the United States is critically undercapitalized and on average needs 20% more, it is a bit of a radical notion. And I think that was what has prompted an unprecedented response. I would add that response from my organization, the Bank Policy Institute, included, I think, over 200 pages in comment letters for every asset and exposure in that proposal, going through what the appropriate risk weight would be, what the data shows, what the analysis shows. The proposal, although it's 1,000 pages, didn't include any of that. Basically, they said, here are all the risk weights, and they gave no explanation for how they were derived. So I think that too has been unprecedented. And again, when you think globally, no one else seems to be doing this. And again, I think it's telling that for the first time, the end users of bank products have said, this is so off market that we need to stand up as well.
So I was shocked when I saw the first of these TV ads on a Sunday night. I was watching the NFL to check I had a fantasy game on the line. And I saw this ad. It wasn't a BPI ad. It was a different ad.
We can't afford TV. But.
And I tweeted about it because it was just, having been in this space for 20 plus years, I'd never seen that. But I have seen a lot of ads, especially being a native Washingtonian, having lived my entire life basically inside the Beltway. You see ads, a coal fire plant, call the EPA, call the FDA, you've seen that about other agencies and rules, prescription drugs, Congress is going to take away, Congress is going to add, make sure doctor reimbursement, blah, blah, blah. This was different because it's targeting the Federal Reserve. And a different type of ads, right, have also, one was call Congress and yell at the Fed, tell them to stop. And the other was call the Fed. And directly, and that to me, what's different here is, one, it's moving to the same, which is there's a bank regulation is being taken to the people in the way that other levels of regulation are being taken to the people. It is becoming easier to explain, as Greg kind of articulated the bank's argument as to what its impact is, right? It used to just be a little complicated to make that argument as opposed to prescription drugs or lead in the drinking water or coal in the fire. One group says, stop the coal because it's polluting and giving us smog and greenhouse gas, and the other says, if you stop the coal, your prices are going to go up and you're going to pay more for heat. people can kind of get the trade-off, and that's a political system, right? Bank capital is very esoteric in this question about what are the financial crises, what are the implications on lending, blah, blah. The second part of the advertising campaign that to me is quite interesting is not the call Congress and complain ad. It's the Fed is trying to hurt the American economy. To the extent the Federal Reserve has agglomerated power for quite some time in a broad array of areas and is exerting itself to some degree more and more like a fourth branch of government, it holds itself in very high esteem with the American public. And unless you're a financial news junkie, you're not really consuming much news about the Federal Reserve and things that are undermining its confidence. Right? I've never seen an ad saying call the Defense Department and have them stop blank munitions. Right? It's always call Congress, more defense budget, less defense budget, peace, war, whatever you want to be. Right? It was meant that Congress made that decision and then the Defense Department implemented it. The Federal Reserve makes a lot of these decisions on its own, as Greg says. Just to close in contrast, we had a European speaker earlier, and I remember doing an exchange when I worked in the Senate with the European Parliament. The European Parliament voted on Basel. It went through the parliamentary procedure and it was open for amendment. A European member of Parliament could have proposed a substantive amendment to the rule, and they would have had a vote on it. That's unthinkable in the US congressional context, but it shows other democratic regimes debate these rules in their elected official as opposed to their regulatory arm.
Right. Yeah, I just want to make one sort of larger point because I was thinking about this on the way up because the panel's about the politics of bank regulation or whatever. And I think there's a difference between politics and partisanship. I'm going to put partisanship aside. When I worked at the Fed, say 1990s, and then I was at Treasury, late 90s, early 2000. The Fed had a very small ledge affairs shop. I think it was 2 people. One of them, I think, was a Civil War reenactor. I don't think they worked very hard. Press shop, very small. It was like maybe 1 or 2 people. The notion that we would leak any information, not just about monetary policy, but about regulatory policy, was anathema. It was just unthinkable. We would periodically get in letters for Congress. One of my jobs in the legal department, because I did sort of policy work there, was to respond to the letters. We generally ignored the letters unless they were from a committee chair, maybe a ranking member, but generally a lot of times just threw them out, but certainly gave them nothing. And then I think that was pretty much the case for a while. And then something broke in the financial crisis. First of all, maybe credit to our morning speaker, agencies started leaking everything, FDIC especially. And what do you know? You can always tell in Washington who leaks by who gets the glowing portrayal in the story. It's not complicated. And I think initially the other agencies were enraged by it. And then after they got bad stories written about them and the FDIC was portrayed as the hero, well, they started leaking too. And that became sort of a cultural thing that, again, those of us who had been at the Fed, maybe Con feels the same way, it was just unthinkable. And then I think the other thing that happened was people forget that after the global financial crisis, the Fed was fighting for its supervisory existence. There were serious proposals and a lot of support for the notion they should take the Fed out of bank regulation. And so the Fed, they started answering those letters, you can bet, and meeting with members of Congress and carefully managing their press. And of course they should, right? I mean, what else would you do? And then we started seeing leaks about supervisory information. It's, so-and-so isn't responding well enough. There's an enforcement action contemplated, which inevitably seems to involve the bank eventually agreeing to that enforcement action as opposed to contesting it. In recent months, we've even seen links about material matters requiring attention, so like minor supervisory criticisms. And I don't think any of this is Republican or Democrat. It's simply that these agencies post-global financial crisis are very much in the public eye. They're very concerned with their reputation. They're very concerned that their powers will be taken away. And that's why, sort of coming full circle to Aaron's answer, that's why the notion of the banking agency running political ads in the 1990s or 2000s would have been laughable, because like, what was the point of that? Well, now you kind of gotta, because the people in Congress who conduct oversight actually testified on Basel Capital 2 days ago, I think. They're asking really hard questions. They're up to speed, and their views matter. It wasn't just, as I talked about the comment letters being 97% opposed. In Congress, I think there was only one Democrat in that committee who basically endorsed the proposal. All the others were criticizing its impact on small businesses, capital markets. The Republicans were universally opposed. And so, I think it's unfortunate, but I think we're in a world now where things like that matter. And that's why you see unprecedented, sort of tactics by the banking industry.
Yeah.
I would also add, by the way, in response to an earlier comment, even to this day, the banking industry spends very little money on lobbying and advertising. If you look at any other industry, and I have, if you look at crypto, oh my God. If you look at fintech, banks are just, I think, notoriously cheap when it comes to this. Somebody was joking about, is there going to be a bank's Super Bowl ad? And I was like, well, I think it might be stop bot, because that's all we could afford. I mean, or at least I can. Maybe somebody else will come in.
In that regard, we invited Sam Bankman-Fried, but he couldn't be here to join us today. I would like to echo, first of all, for all those Civil War reenactors online, his name is Greg Bear. You can reach him at.
There's nothing, not that there's anything wrong with that. It just takes time.
One issue that has not come up in any of the discussion today, I'm surprised it hasn't, is the matter of the major questions doctrine. Major questions doctrine. That's the Supreme Court case that says that major questions have to be decided by Congress, not by administrative agents. It's a cousin to the Chevron doctrine deference, the case that we will be hearing about later in this term.
Next week, isn't it? Well, it was argued last week.
So, Greg, and I heard you talk or complain about the lack of data backing up the asset risk classifications, and I'm on board with that. Is there a thinly veiled judgment on your part that the Fed and the agencies are on treacherous legal grounds if they move forward in this regard?
Oh yeah, I'll talk about APA then a little bit on major questions. It isn't really, major questions is basically a baby step towards the non-delegation doctrine, which really hasn't been in place since the 1930s. And the non-delegation doctrine is basically Congress can't cede to the executive branch its authority to legislate, so it can't give agencies a broad mandate like fix banking. Major questions is a subset of that, because it's basically saying, we will assume, we'll have a little more scrutiny on major questions, or we'll ask the agencies to do more, or we won't assume that Congress did something major without, it's being specific. But we're more focused on the APA in this case. There are procedural requirements and substantive requirements to the APA. The procedural requirement really boils down to show your work. That is, you need to document the basis for the rule, and then you need to give meaningful opportunity to commenters. Meaningful meaning they know what the basis of the rule was. The substantive side, I'm sure you've heard the term arbitrary and capricious. Substantive side of the APA is that when you adopt the final rule, it has to be based on substantial evidence that you can demonstrate. Also includes you need to consider other alternatives that were proffered by commenters, and basically you need to engage with the comments and explain why you did not take them. We haven't gotten to the final rule on this, but certainly the proposed rule has problems on both those fronts. The work was not shown. You saw, just to give one example, which came up a lot this week, there are Basel risk weights for mortgage. They are probably double what historical experience shows in the United States. The US agencies proposed to add 20 basis points to each of those for each loan to value category. They did so without any explanation whatsoever. No data, no analysis at all. Just here, take 20 more basis points. So you see that really for every risk category in the proposal. And again, we went through every single risk. There's a proposal right now, you don't hold any capital against unused lines on credit cards. Actually important for low, moderate income people, because for a lot of them, that's an emergency line that you use instead of going to a payday lender or something like that. The proposal says, well, we're going to take that from 0 to 10%. Now, it actually should be probably higher than 0. But I think the evidence shows it's probably closer to 5 than 10. But again, that's what our data shows. They had no data. And it's really important too, because banks will cut those lines if they have to hold capital against money that they haven't even lent. So that's where you see time and again under the proposal that there's no there. And I think that's why we, and again, lots of other commenters are saying, look, you can't just finalize this. You have to give an opportunity to comment. And a lot of that has been around this sort of so-called quantitative impact study, because the first question you want to know is, well, how much is capital actually going up and in what areas? They did not do a very good job of that. They actually say they're going to redo it. They had announced, I guess that's still the pending announcement, that they will finalize the quantitative impact study at the time they announce the final rule. Well, that's not how it's supposed to work under the APA. You're supposed to get a chance to see the impacts and then comment, not have them announced at the same time that the rule is finalized. I mean, I think we and others have argued, and I think there's probably a decent chance, once the lawyers look at it, that it should be reproposed with smarter risk weights based on more data and analysis.
Okay, I'm getting the amber light from Marina here. So do we have any questions in the audience? And Tim? Can we get the mic to Tim? And do we have one online or more?
Yeah, we have a couple from online.
Couple online, good.
So a kind of a weak attempt to tie this morning's session in with the wrap-up session here. CBDC seems to be kind of a fancy name for giving the rest of the people in this country a Fed account and access
Central
to
bank digital currency.
Yeah.
Yeah.
I mean, that's all it really is, I guess. You can correct me if you disagree. But, a lot of people believe that the Fed protects banks because that's not happening quickly enough, which you sort of have another view, Greg. But would that address some of these problems in terms of risk orientation and systemic risk if people had the alternative for a risk-free account?
Let me respond to that. That's a cash mutual fund. If I have put my cash in a mutual fund that just holds it, maybe they just hold it with the Federal Reserve, and if I buy, central bank digital currency, that's like holding my money directly with the Federal Reserve. It's like a Federal Reserve bank account. That's a cash mutual fund. And so that would be perfectly safe. It's perfectly liquid. That was a proposal called narrow banking presented by economists in the 30s, Irving Fisher and Frank Knight from Fisher was Yale, Frank Knight was from Chicago. That was their response to how to try and restructure the banking system. Limited purpose banking, which I'm proposing, has narrow banking as a small component of a big version of making all the financial accounts 100% equity finance. So when you have a cash mutual fund, when you have your money with the Fed, it's 100% equity finance. They're not borrowing any money and then promising, or borrowing money from you and then promising to pay it back while they lend it out. They're just holding it, charging you a fee to hold it. And same thing, going, if you look, I think one thing we're kind of missing in this discussion is the bigger picture, which is we're having a lot of conversation about what agencies and rules should be overseeing how to fix the bolts on that BU bridge, when there's another bridge down the river, Salt and Pepper Bridge, was built never to fail. And I think that our financial system is gradually moving towards the Salt and Pepper Bridge. I think that if you look at the banking system compared to the equity finance mutual fund system, that the ratio, maybe I've got the numbers wrong, but I think the ratio is heading towards more equity finance mutual fund banking. And that when you saw the crisis a year ago with Silicon Valley Bank, what do those uninsured deposits do? Well, lots of them moved right to the mutual fund industry. I'm not, by the way, connected at all with the mutual fund industry. I don't have any stake on every, I'm not
Greg,
a lobbyist.
Greg, will you explain to us what the salt and pepper bridge is?
Well, I'll just say this. If anybody's interested in central bank digital currencies, although I'm going to say in a moment you shouldn't be, I've done, I think, 3 or 4 research notes on it, including a 20-page basic explainer of the mechanics of it, which is kind of interesting. There isn't going to be, I think, in any time in the future, a central bank digital currency in this country. Here's the fundamental of a central bank digital currency and why it's a problem. If you put a deposit at a bank, you're lending money to your bank. The bank takes that money, they lend it to businesses, they lend it to people. If you have a central bank digital currency, you're lending money to your government, just the way you would if you have a $20 bill in your pocket, and they use that to fund the government. They don't make loans. Now, you could have a world where you have a central bank digital currency, and the Fed takes that money and they make loans, but that's probably not the country we want. The other really fundamental problem with central bank digital currency is in crisis, 2009, 2020, people would always want to hold a riskless asset, right? And so if you want to see a run out of the banking system, we'll allow people to have an account at the Fed. And it doesn't have to be for a long time. And don't think about individuals, think about corporate treasurers. You're a corporate treasurer, you got $50 million on deposit at a large bank. And something horrible happens. Maybe it's a war, maybe it's a missile launch. And you say, you know what, just today, I'm just going to take my money, click of the thing, and I'm going to have my money at the Fed, effectively in Fed reserves instead of at my bank. Well, that implodes the banking system.
Not if there's no banks. Not if there's no
okay,
banks.
well, we can do that some other time.
So let me just chime in on a few different points, right? The Federal Reserve is not legally allowed to directly provide accounts to people. The Federal Reserve, according to the Biden administration's Justice Department, could not do a central bank digital currency. Originally, when proposed, the Federal Reserve said, we will tell you whether or not we have the legal authority to do this. The Biden administration put in an executive order, passed it to the Justice Department. Justice Department said the Fed doesn't have the legal authority, although no one's seen the Justice Department memo. I think that somehow got put in Greg's not to be shown to Congress, which is to me somewhat striking because that should be a public piece of information. So if the Fed can't offer you a CBDC, there has to be a pass-through. There's somebody that becomes an intermediary. That person could also offer you money. What most people in this room and watching online don't think of is you exist in a CBDC world. Everything you buy is commercial bank digital currency. You think your money at the bank is money. Unless you have physical cash, you do not have a liability. You have a liability of a bank. And commercial bank digital currency has pros and cons. We can debate it. I have some criticisms of the system. One thing we can all acknowledge is the system, really, it works to a point, right? We all transact in money and we all have faith in it. If we were having this conversation in the 19th century, we would discount each other's bank deposits based on our view of the health and solvency of that bank. That was like a real thing. Right now it isn't. All bank money is created equally and it translates at par, right? In fact, we've taken that confidence even to sending each other Venmos and PayPals, which are not commercial bank digital currency. They are digital currency, right? They're a technology digital currency. Point 2, I don't know where Larry is on this. The Federal Reserve runs an $8 trillion lending operation. Their balance sheet, I just looked it up, is it's 7 point, as of this week, it is 7.63 million, right? Primarily mortgage-backed securities, some corporate debt they bought during COVID, some dogs, cats, and who knows what else in that. So the idea that you're putting your money at the Fed and the Fed putting in a lockbox, which is just money, no. The Fed is buying your mortgage, your junk bond in the name of COVID relief, and they're running a very levered thing. Now, the argument being, well, if their stuff defaults or if their stuff goes under, right, because a lot of their yielded mortgages are worth less than existing yields, so marked on a par value would lose money, then there's a magical debit and the deficit goes up because the Federal Reserve draws money from the Treasury Department. There's a little bit of circularity. If you get too far down the money thing, you start talking like you're not making any sense because there's a circularity of it all. But it becomes deficit financed, which then is simply, you instead of losing money and having the system go awry, you're just losing money and charging it to future generations to pay you back.
So Aaron, there's a limit to how much we can expropriate future generations to make sure that the current bankers can continue this game of putting the country at risk. The Fed does not have infinite power to bail out the financial sector. And if all you have to do is go to Argentina and see that, talk to the economics minister that was there in 2000, Domingo Cavallo. They had deposit insurance, and there was still a run on the banks, and they had to close down the banks because if they didn't close down the banks, they would have to print so much money that there'd be so much inflation. Expect there was inflation anyway, that people would run just to get their money out and spend it before the inflation went up, prices went up. So it's not like the Federal Reserve is our savior in all states of the world here. You have to, think about the bigger picture here, that the Fed is pretending that they can protect the banks through this regulation, which they, and then they're persuading the public not to run because the Fed's there. But if that panic is deep enough, people will run, and the Fed will not be able to stop it, and things will collapse just like they have in Argentina many times.
And the name of the book is Jimmy Stewart is Dead, for those of you listening at home. Question from our online group.
Yes. So, hold on. The question is, would the panelists please comment on the risk of the politicization of industry groups in communications with Congress and the public? In particular, industry groups have, over the last several decades, developed gravitas and credibility as information providers with limited partisanship. Why the departure? Is this costly or a search for relevance?
Take it away, Greg.
Well, I mean, all I can say is what we do. So we have a team of PhD economists and research assistants. We put out academic quality research. I would commend it to you if you want to understand any aspect of this proposal. We have it with algorithms that I can't understand. And, our whole idea and sort of mission statement is the only way to influence policy, particularly at the Federal Reserve, but also the other banking agencies, where most of the work is nonpartisan and apolitical, is to produce research that they understand and appreciate, and come to conferences where that's discussed. And I think that's how you have influence. And I think that is, tooting our own horn, I think that's been very effective, particularly when you can occupy the field. Because when you listen, and I think if you review, the statements of folks who are somehow supporting this proposal, they don't cite data. They use ad hominems. They talk about how the bankers are corrupt and, how much money they're spending. But, we've probably published 24 academic quality research notes on this proposal. I've not seen a single person point out an error to me in any of it. Nobody said it's misleading. Nobody said the data is wrong. So you're actually in this weird spot where we're the objective data providers, and it's the other side, the sort of bizarre anti-bank lobby that's grown up post-crisis, that is political, ad hominem, and completely lacking in data analysis.
So I was having this conversation with a similarly aged friend who was making yesterday, who was making the former Treasury colleague of mine, who was making the argument that our the cohort of people, for simplicity's sake, born in the 70s, are the most reasonable cohort of people. And in our self-congratulatory back and forth, we were discussing about how we grew up in an era where there were 3 news channels. There was daily newspapers of high quality local journalism. And you pretty much had access to the same quote unquote set of facts. And now we live in a world where social media and alt facts and people are instead getting information that is often reaffirming prior biases as opposed to seeking common truth. And I think it is incredibly important for everybody to go out and read something from a source that you normally disagree with and listen to what they're saying and why. Look at their data, their numbers, their logic, their argument, their predicate. Because there's generally an internal logic inside of it. And it can sometimes If you can't say why I disagree, why their internal logic makes sense, then you may actually have to question your own prior, which is a wonderful thing to do, because too much information is about reinforcing priors. And the question, I think, tends to lead to the argument that, well, if industry puts out some analysis, I should discount it because it's self-serving. And that's a horrible thing to say. If industry puts out some analysis, read it. See what they're saying, listen to it. If anti-industry puts something out, read it. See what they're saying, listen to it. Do not simply discount the facts of the side because you think you disagree with them a priori on either end of that.
Let me just add here something different, which is or opposite. Industry is very, is well paid to put out its, collect its facts, that support its argument. The general public, there might be some groups that, are anti-bankers. They're probably not well organized. They're not well funded. But the general public is facing a free rider problem. Why should I spend my time to really research this issue when it's going to help everybody else? So that's, a very asymmetric situation here in terms of this discourse about policy. We have lobbyists, just again, go ask whether any nonprofits are supporting the campaigns, are the main donors to the members of the House Financial Services Committee. Just go look online at who are the donors to the contributors to their campaigns. It's all the major banks. I think that says a whole lot.
I would note there are dozens, maybe hundreds of nonprofits who have weighed in on the side of the banking industry with regard to this proposal. Maybe they're hopelessly corrupt in ways I can't imagine, but I don't think so.
I can't hope, but
well-funded.
When I hear nonprofit, I think about next Tuesday when at the Brookings Institute, we will host the chairman of the National Credit Union Administration, the credit union regulator. Credit unions are supposedly nonprofit entities. I'm aware of one that bought their CEO a private jet as they've grown to be I think, $40 billion institution. I don't know what their CEO makes because as they're the only federally chartered credit unions are the only nonprofits who don't have to file what's known as a Form 990, which is executive comp disclosure, right? If I wanted to look up and see how much the top executives at Greg's organization make or at any of the banks, I can look it up. You can't do that for credit unions. What I can tell you is a state chartered credit union out of California increased their CEO's executive comp to $12 million a year, while the institution charged $18 million a year in overdraft fees. And that's considered a quote unquote nonprofit. So maybe these conversations will excite people to tune in on Tuesday to the Brookings
Aaron
Credit
really
Union.
doesn't like credit.
Speaking of landing this plane, Arena, one more question?
No, I think
love credit
that's all we have
Oh, that
time
was
for
it.
today,
Oh, okay.
yeah.
Oh, good.
Well,
Let me just summarize, if I could. Aaron, you made the point of the Fed not having the legal authority to do central bank digital currency, and I hear you. But any of you that have been to the Fed, there are two main buildings. There's the William McChesney Martin building, and then there's the Mariner Eccles building. And
they're actually building a third.
And they're building a third. Well,
I thought they only had legal authority for 8 buildings.
so the federal, when the Fed wanted to build the Martin building across C Street, it looked at the Federal Reserve Act and it said that it can build a building, and it already had a building. So the judgment from the legal counsel was can't build the building. But the solution was to put a tunnel under C Street and call it an annex. So it's not really the Martin building, it's the Martin Annex, right? Complete with what's it called? Squash courts.
I love those squash courts.
Yeah. One other point to the last question. We've talked about the Supreme Court several times today in each of the panels, obliquely, Chevron, major question, all of these kinds of things.
Sorry, I got confused. It's preemption that's being argued next week. Also a big
It's
case.
already been argued.
Preemption is being argued.
I thought it was already argued.
Antero.
No?
No, Chevron was already. The
Chevron
case
was
already
argued.
That was,
Okay, I'm sorry.
That was already ordered.
Yeah.
argued 2
But
weeks ago.
to that point, there is a powerful third branch of the government here that is more powerful than it has ever been. It's probably more discredited than it has ever been, and it is probably more ideological than it has ever been. And I'm not going out on a limb by saying those things. So to the last question that was asked, there is another Supreme Court case that should be in the mix here, and I think that is the Citizens United case. If you don't like your Supreme Court now, voting in November is one way to address that. If you do like your Supreme Court now as is, then voting in November is a way to address that too. And finally, I just would like to express my disappointment that we did not get to see Larry in his tuxedo today, fully dressed, because I think that would have stolen the show.
Okay, next time.
All right.
All right, thank you to our panelists.